It's a few minutes after 12 o'clock. We are starting the meeting. Your Excellencies, distinguished delegates, greetings from Geneva. To introduce myself again today, my name is Dumisani Dlala. I'm the head of the ATT Secretariat. I am addressing you from Geneva, the seat of the ATT Secretariat. We have a whole week of ATT meetings set for this week. We had a first set of sessions yesterday, and today we are proceeding on the similar trajectory. But for today, we have two sessions planned. One is a discussion on Article 9 that will run for 2 hours. And after that, we'll have a working group on treaty universalization. Before we start with the meeting, I would like to remind you of the housekeeping rules. I know that I read the rules yesterday. Some of you who were present here today would remember them, but some may be joining for the first time. So I need to take the opportunity then and advise them of the rules that are applicable to these proceedings. The first one is that we would ask all the delegates who have joined this meeting to turn off their camera and microphones during the course of the meeting. And we particularly make this call to some of the delegates who are using the mobile phones. There's been a few yesterday who have accidentally unmuted themselves and were unable to, they had interfered with some sessions, some part of the sessions. So we request that everyone must turn their camera as well as microphone off for the duration of the session. Yesterday, we announced that there is a speakers list, and we have a speakers list for today. The closing date for the submission of requests for the speakers list was 1800 hours Geneva time yesterday. So this morning, we published a list of speakers. It is available on the ATT website. So at this point, you should know where you stand in terms of the speaking order. When the time comes for the speakers to start to deliver their interventions, we will call speakers in the set of threes. So this will enable us to be able to facilitate the interventions so that each and every speaker would know when he is next to speak, and then he can get himself or herself ready to take the floor. And of course, then if you are giving a statement on behalf of your government or your organization, you would proceed then and unmute yourself if you are called upon to take the floor. If you are not on the speakers list, you have an opportunity to still request to be on the speakers list, but you can use the chat function to request for the floor whilst the meeting is ongoing. We'll monitor the chat function, and at the right time, we would inform delegates of those who are online to speak. And of course, those who are requesting to speak from the chat function would only speak after we have exhausted the published list of speakers as it appears on the website. Today, as it was yesterday, we have some of the sessions having some presenters. So you'll have the opportunity then to direct a question to the presenters at the right time. And the plan is that you would be able to ask a question directly to a presenter immediately after the session or the presentation of the speaker has been concluded. But if you want to ask a question directly to the presenter, you have to indicate as such using the chat function. For example, as I said yesterday, you would write, country X has a question for an expert from ICRC, as an example. But today we've got a different set of speakers. Another point that I would want to bring to the attention of delegates is about the inability or difficulties that speakers who have been called upon to speak may have to come online or to connect in a timely manner. When that does happen, where a speaker is called upon to take the platform and is unable to do so because of connectivity problems, or the sound is not coming through well, we would proceed to the next speaker and come back to the speaker who had a problem later on. So this is to ensure that we are not interrupting too much the proceedings, the flow of discussions. And finally, the meetings that we have now, they have interpretation in all 6 UN languages. And if you go to the bottom of your screen, you can see that there is a button that is written interpretation. If you click on that, you will see 6 languages, and you can choose the language that you prefer to use. Of course, if you do not choose any language, what you'll hear is a language that is used by those who are making interventions or those who are making presentations. So it means the language in which the statements are made is a language that we'll hear in a year if we have not chosen a different language. So those is a reminder of the housekeeping rules that will be applicable for the duration of today and tomorrow and the rest of the week. As I said, there are 2 sessions for this morning. One is a 2-hour session on Article 9. And after that, we have a working group on treaty universalization that will run for an hour. The first session is moderated by Mr. Rob Wensley. Mr. Wensley, as you can see, is not sitting with me here because he's be facilitating his session from the capital of South Africa, that is Pretoria. So I understand that Rob can see me and can hear me. And without any further waste of time, I'll cross over to Rob Wensley in South Africa. Rob, over to you. Thank you.
Thank you, Dumisani. I'm just trying to set up my system here that I can be seen.
Rob, at this point in time, we can see you well. We just disappeared. But for a moment, we could see you well. I think you may not need to interfere with your connections at this time.
Okay. All right. Well, first of all, thank you, Dumisani. Thank you, everyone, for attending this virtual session. I also wish to thank the president of CSP7, sorry, for the arrangements thus far, and also for the Secretariat's assistance in putting together this week's program, together with the co-facilitators and the president, obviously. This particular working group, sub-working group, as most of you would know, is the newest and the youngest of the 3 sub-working groups. As such, not much progress has been made. We had a February session last year in Geneva, at which we had kind of an initial exchange of views, I would say, on this particular area. I just wish to emphasize that in terms of the draft multi-year work plan for Article 9, we'll split this in 2 parts, as Dumisani said. And the first part being specifically on arms control. And if you look at that multi-year work plan, you'll see there are certain questions that still need to be looked at. Three of them are the first being how states parties approach the term transit in their national practice. I wish to emphasize national practice. Secondly, how do states parties approach the term transshipment in their national practice? Thirdly, do states parties apply the same regulations, transit and transshipment in their national control systems? The third one is basically just a clarification question. We also need to look at towards at a later stage. Has sufficient time been allocated according to the states parties to these issues to unpack them? We have, as Dumisani said, two experts this morning, one each carrying responsibility for doing an input for us for the benefit that we might have on the two topics that are on our agenda. Before I introduce the first expert, Mr. Diederik Kops, I would just like to say that from my own point of view, my name, of course, is Rob Wensley, you might have heard. I'm the Deputy Director for Conventional Arms in the South African Foreign Ministry. Amongst others, I deal with the Arms Trade Treaty, a whole host of other humanitarian / disarmament treaties, from anti-personnel mine ban treaty to cluster munitions to CCW, quite a few of them. That's essentially about it. If I may hand over the floor to Mr. Diederik Kops, who will give us a brief presentation. As a kickoff speaker, Dr. Kops is a senior researcher at the Flemish Peace Institute, an independent research institute on peace issues affiliated to the Flemish Parliament in Belgium. His main area of work focuses on the international trade in conventional weapons and on the legal, political, and practical aspects of arms export controls. He's currently working on a study commissioned by the Committee on Foreign Affairs of the Flemish Parliament on the issue of transit controls of conventional weapons. That's just by way of introduction. What I would suggest, actually suggested by Secretariat, I would agree with that. Following Dr. Kops's introductory remarks, I will open the floor for questions directly to him on his presentation. So if you have a statement to make under topic 1 in your national capacity or on behalf of a group of states or international organization, so just hold off on those. There'll be time for that later. So without wasting any much more of your time, I hand the floor to Dr. Diederik Kops.
Thank you, Mr. Wensley. I hope I can be understood clearly at the moment. I will try to share my screen because I prepared a presentation, a short presentation on the issue that I would like to give some insights on. I hope the presentation is viewable at this moment for everybody. What I was asked to do is to give a short presentation on the issue of transit controls and how, based on our study, in this respect, 7 European countries deal on a legal basis with the issue of transit controls in their national legislation. I was already introduced by Mr. Wensley in a very kind manner, but just to say that as a Flemish Peace Institute, which is a very small institute, so we're very grateful that the ATT Secretariat has thought about us to give, to share our insights on this issue during this, this meeting. We've done quite some work on the international arms trade in general, but we've also done some work on the issue of transit more specifically. We already did an analysis in 2012 of transit control systems in several European member states, a study that's available in English, still fully and freely downloadable on our website. I've included the link in the presentation, which will also be shared by the Secretariat. So for those interested, always feel free to take a look and to see what our insights in that respect were at that moment. As already was mentioned by Mr. Wensley also, is that we're currently again doing an analysis of transit control systems for conventional weapons in a broader subset of countries in Europe. But next to this, let's say, national comparative analysis, we're also focusing or studying ways of identifying possibilities and challenges for international cooperation and information exchange to optimize transit controls on controlled conventional military goods. So the things that I will share in the coming minutes are actually coming out of these analyses, but they at the same time come with some kind of a disclaimer in the sense that our study is still ongoing. So it might be that some of the conclusions that we're drawing right now will be still need some more backing and will be even become more disaggregated whilst our analysis takes further steps in the next coming of months. And it's a study that we hope to end or to finalize by September or October of this year. So you might ask why the Flemish region or the Flemish Parliament is so interested in this issue. Very shortly, although Flanders is a really small area in Europe, let alone on a global level, it's a very important transit region in the sense that we have 4 seaports and also several airports on our territory, of which the Port of Antwerp is, of course, probably the most known one, but also on an airport level, the Brussels airport is one of the larger cargo transport airports in Europe, which makes it very relevant and makes it a highly topical issue from a Flemish perspective. But when you look at a European perspective, you can see, as probably all of you will know, there's a lot of transport and transit taking place in Europe with a lot of ports, both seaports and airports, very closely situated towards each other. But this geographical concentration of a lot of ports on a very close geographical area, albeit that all of these systems, all of these ports are situated in different states with their own national regulatory systems, will bring about some challenges in order to have an effective and efficient transit control system, on which I will come back very concisely in my, my final conclusions of my presentation. So without further ado, let me try to address some of the questions that were guiding my presentation. And I was asked to share some insights on how in these different European countries, the topics of transit and transshipment, which was the first part of the set of questions, how these topics are defined in export control legislation, so from export control perspective. And when we look at these definitions, and I've listed most of these definitions here on the slide, the general conclusion is that we can see that most of these systems on a legal basis use a broad definition of what they consider as transit and as possibly controlled transit from an export control perspective, which de facto includes both transit and transshipment. And although most systems do not make that difference or that division between the two aspects explicit, with the exception of the UK, they mainly, because of their definition, which focuses on transport of goods over their territory, it implies that it includes both transit and transshipment. So by the definition of the concept of transit and export control, there is in general a very broad definition that we just used, in that sense that, and as a consequence, you have a broad legal basis, possibly allowing these countries to control a lot of possible transit transactions and very different modes of transit. There are some exceptions that we found currently in definitions in the Walloon region in Belgium and Spain, which do not have that kind of specific definition in their export control legislation, but they refer to specific elements and specific concepts in EU customs law. On the consequences of that, I will come back in my next slide. And it relates when we go then to the issue of transshipment. And as a consequence of what I just said, namely that most of these states of these systems use a very broad definition of transit, it means that in most systems, transshipment as such is not explicitly defined, but is implicitly included under the legal definition of transit. There are in some systems we can find some more explanations and some broader descriptions that give a better insight on what is exactly understood under transshipment. For example, in the legal system of Flanders, we can see that transshipment deals with two types of transshipment, not only when the goods are loaded from one mode of transport onto another, but also when the goods are unloaded from one mode of transport and subsequently reloaded onto the same mode of transport. So these both kind of transactions are seen or are defined as transshipment transactions. In France and the French legislation, a distinction is made, especially regarding which transactions are put under a license requirement, based on the question whether the goods effectively touch ground in French ports. So when the goods during a transshipment, during an unloading and reloading on another or the same mode of transport, effectively touch ground, that might have an impact on whether or not the transaction is subject to a license requirement. So there we have a different aspect of transshipment, not only looking at if there is a change of mode of transport, but effectively looking at whether or not the goods have effectively touched ground on French territory. And as a consequence of what I just said, when looking at the Spain and the Walloon region, who refer to specific concepts in EU customs code, more specifically seeing transit as customs warehousing or free zone procedure and the external transit procedure, this in reality means that in those two systems, transit is specifically defined as transshipment. So as a consequence, their legal definition of transit is limited to transshipment, which in principle means that from a legal basis, there is no possibility to also apply controls on mere transit transactions where goods merely transit over the territory of these two regions or countries. So this on the basis of the definition of these two central concepts in the control of transit. However, although these definitions are very crucial to understand the legal basis on which countries or systems can possibly control transit transactions from an export control perspective, what's equally important, and that relates to the third question that was guiding my presentation, one has to look at which transactions are effectively being controlled, or in other words, which transactions need a transit license from an export control perspective. And when we look at that issue, we can see that, and this is only an analysis of 7 systems, we can see that the picture becomes much more complex and much more diverse, and that meant that there are substantial differences between these different countries regarding which transactions are subject to a license requirement. And although we can see that there are some generic principles that I would like to discuss in the next coming slides, I will also try to illustrate that there are substantial differences between member states, how they effectively implement that in their own national legislation and their own national systems. So as a basic principle, we can say that which all systems have in place and which is common to all these systems is that they have clauses to forbid transit to embargoed countries and transit of certain military items, such as cluster munition or anti-personnel mines. Transit of these goods are in principle forbidden within all of these systems that we're currently analyzing. Next to this element, we can see also that member states have a more narrow approach and that they only have kind of a systematic license obligation for specific elements of the broad concept of transit. Most systems specifically focus on transshipment, which they see as the most sensitive element in the broad aspect of transit. And most systems try to control transshipment transactions on the territory. Other systems also focus on specific types of military goods and distinguish between based on the sensitivity of the military goods. Germany is a good example in this case, in the sense that it only has a license requirement, systematic license requirement in place for both transit and transshipment of weapons on the war weapons list of Germany, which is a specific subset of a broader group of defense-related goods. And it's only these goods that are considered to be the most sensitive ones that are subject to a systematic license requirement when transited or transshipped on or via German territory. The UK combines this sensitivity of military goods with a sensitivity regarding the countries of destination or the countries of origin of the controlled goods, and implies some kind of a three-tier regime in which tier 1 are the most sensitive goods, mainly security and paramilitary police equipment, which has a systematic license requirement, followed by tier 2 and tier 3, in which both the sensitivity of the goods decreases as well as the sensitivity of the countries of destination. And only in each of these cases, you can see that the systematic license requirement becomes more and more narrow, while other transactions are in principle free or exempted from a license requirement for in the case of transit or transshipment of these kinds of military goods. However, the systematic license requirement for transshipment or for specific types of military goods is always, in most of these systems, combined with more flexible licensing regimes and exemptions to the general rule. We can see that in the systems that we're currently analyzing, several countries make use of general licenses or global licenses, which allow for a more flexible, more liberal approach in which controls are not in place for each transaction, and each transaction before the transaction takes place needs to be assessed thoroughly by the export control agency. But in this, for example, in the case of general licenses, transport companies only have to report annually, for example, on the number or type of transactions that they've been conducting via the territory of that country. So for example, the Netherlands, they have 2 general transshipment licenses for transshipment transactions that are destined to or originating from allied or friendly countries. And as a general principle, this actually, you can see that countries use these kind of more flexible regime types to decrease controls on transactions that they deem are less sensitive than other transactions. Others have exemptions in place on that systematic license requirement. For example, Flanders has a systematic license requirement, for example, for transshipment on Flemish territory, but exempts transfers or transit that's destined for EEA countries, so the European Economic Area countries, NATO members, and certain members of the Wassenaar Arrangement. These kind of transits or transshipments are also exempted from a license requirement. And what all member states, all these countries also share, which is particular to the European context, is that because of European rules, transport between 2 EU member states or their armed forces over the territory of another EU member state is also exempted from a license obligation. So we can see that member states have this especially try to catch and systematically control those kinds of transit transactions that they see are the most sensitive ones. However, in most systems, or almost all systems, we can see that is combined. The systematic license requirement is combined with the possibility for an ad hoc transit license requirement, especially for transit. For example, Flanders since 2017 foresees the possibility to install a license requirement for specific transactions when the goods are destined, for example, for countries under an embargo, are intended for commission of genocides, crimes against humanity, or war crimes. And what all systems seem to share is that they are able, or they foresee the possibility, the legal possibility, to also ad hoc control transit transactions. So in a broad perspective, if these transactions might be in contrary to international obligations, or could violate the essential security interests of the state or the government in which these transactions might take place. And that's something that we can see in most countries or systems that we're currently analyzing. So let me end with some basic conclusions. And in a generic way, or in a general way, let me put it that way, that we see that all of these systems that we're analyzing use a broad legal basis to define transit. It makes it possible for them to possibly control all different aspects, irrespective of whether or not there has been an unloading or reloading of the goods, irrespective of the mode of transport of the goods involved. But in reality, that they use a more narrow approach to control specific transactions on a systematic and effective way, which is then combined with a huge variety in exemptions and possibilities for ad hoc licensing. And it's crucial if you want to understand how countries or governments deal with transit, you have to combine both aspects. You don't only have to look at the legal definition of transit and transshipment, but you also have to look at which transactions are effectively being controlled.
Но также смотреть, какие транзакции подлежат контролю.
What we see at the same time
对不起，我干扰，
plus l'orateur.
听不清楚。
is that there are substantial
You can't hear the
differences.
speaker anymore, unfortunately. Some microphones are on.
有的人把麦克风打开了，
Yeah, I hope it's working
现
again.
在
No, un problème.
还是有问题。
There's a
Проблема.
problem,
Проблема.
unfortunately.
Проблема.
I am hearing the interpreters right now, and maybe there could be.
Monsieur dit
发
qu'il
言人说：“我
entend
听
les
得到口译的声
interprètes.
音，口译也听得到自己的声音，有一些技术问题，抱歉。
Oui, on entend la cabine chinoise, en fait, alors que l'orateur n'est pas en train de parler.
Et cabine russe.
C'est normal, excusez-nous, nous
Je suis
avons
sur
un
la
petit
bonne
problème.
Cabine
canal. La
russe
cabine
aussi,
chinoise est sur la bonne canal. Le canal
Delegates,
chinoise.
Sorry, interpreters, we have a technical trouble. We're just fixing
Техническая
it. Could
проблема.
you let us?
有一些技术问
Nous avons un
题
tout petit
要
problème
解
technique,
决一
quelques
下，
instants de patience pour que nous puissions le réparer.
请大家
We
谅
have a
解。
slight technical
抱歉。
problem, just a few moments patience until we can fix the problem. Thank you very much from the interpreters.
Okay, I hope I'm can understand.
Derek, we can still hear you, but
Oui, on vous
let's
entend.
take
Мы
a
слышим
break for a moment.
вас,
Whilst we're fixing
но
it,
Please wait a
также
few
слышим
moments, sir.
переводчик.
I am informed that the technical glitch has been addressed with the relating to interpretation. I hope all delegates and can hear me. And I do hope that Mr. Rob Wensley, you can hear me in South Africa. And Mr. Dedrick Cobbs, you can hear me as well in Belgium. Can you confirm before you proceed? Dedrick, can you hear me?
Yes, I can.
Rob, can you hear me? All right, so if you can continue, Mr. Cobbs,
That's
please.
okay. I just need a minute to wrap up my presentation. But as I said, what I was trying to make is that we see that there is a shared broad legal basis, but that in reality we see substantial differences between how only, and this is only a selection of 7 countries and 8 control systems, how they deal with what they effectively control as transit transactions, and these substantial differences between countries that are so closely geographically linked to each other in dealing with a phenomenon like transit, which is inherently transnational, it creates various challenges, not only for transport companies for whom it is very difficult or often challenging to comply with all these different legal obligations, but maybe even more important is that it might create possibilities for smugglers and potential proliferators to find loopholes and to exploit loopholes in these systems in these countries that are so situated so geographically close to each other. So let me end by just one conclusion, which I would like to put forward here, which is also based on our experience in trying to understand how these countries control transit of military goods, is that there is a need for increased transparency on the issue. And that transparency should not only be on the organization, scope, and competent authorities of transit controls, which has been shown during our study, which is very difficult to get a good grasp on and to fully understand how transit controls are in reality organized in these countries, but also on issued and denied transit licenses. More transparency should be a relevant thing to take into account, because it might help to get a better view on international arms flows and to understand and to possibly prevent smugglers and proliferators to make use and to shop between these different systems and looking for the most easy way to transfer goods from one country to another. So thank you for your attention. And if there are some questions, feel free to ask, and I'll of course remain available also afterwards to discuss these issues in another way whatsoever.
Rob, if you can unmute yourself, we can't hear you at this point. You remain muted. Can I ask our technical team to unmute Rob Wensley at this point? All right. So Rob, you are now
Yes.
on. Thank you.
Okay, thank you. All right. If I could ask the Secretariat assistance in indicating, I have a speakers list. I've received a speakers list for general comments under topic 1. But if there is a wish to for someone to direct a question or remark in follow up to Dr. Kopps's presentation, I'm unable to see that at this stage, and I don't know if there are any.
Rob, from our side, we've been monitoring the chat room. We do not have a delegate who would want to make or direct a question to Dr. Koppes. So we don't have a question that is directed to him.
Okay, all right. So let's move straight into the speakers list for topic 1. The first 3 speakers for the information of delegations is France, Switzerland, and Belgium. So France, you have the floor.
Bonjour, merci beaucoup, je vous remercie. La France se réjouit de la poursuite de nos échanges sur la problématique complexe de la régulation du transit et du transbordement d'armes classiques. La France considère que le contrôle du transit et du transbordement des armes classiques est indispensable à la réalisation des buts et objectifs du traité. De tels contrôles contribuent effectivement à la sécurisation de l'ensemble de la chaîne de transfert, concourant ainsi à une meilleure régulation du commerce international d'armement, mais également à une meilleure prévention du risque de détournement. Premièrement, le contrôle des activités de transit-transbordement concourt à la réalisation du double objectif du traité, à savoir réglementer le commerce international d'armes classiques et prévenir le détournement illicite des armes légalement transférées. En outre, la mise en place par les États parties de mesures destinées à contrôler et, le cas échéant, à interdire le transit-transbordement d'armes classiques par leur territoire est indispensable à la mise en œuvre des embargos décidés par le Conseil de sécurité des Nations Unies. Enfin, nous pensons qu'un État doit être en mesure de contrôler et d'interdire le transport d'armes via son territoire lorsqu'il juge ce transfert illégal ou illégitime, mais également lorsqu'il représente une menace pour sa sécurité intérieure. C'est pourquoi la France applique des contrôles rigoureux au transit et au transbordement d'armes classiques sur son territoire. Ainsi, au titre de la réglementation française, une autorisation préalable est requise pour le transit de matériel de guerre, armes, munitions et leurs éléments Ainsi, au titre de la réglementation française, une autorisation préalable est requise pour le transit de matériel de guerre, armes, munitions et leurs éléments de frontière à frontière par route entre deux États, dont au moins l'un d'entre eux n'est pas membre de l'Union européenne. Une autorisation préalable est également requise pour le transbordement de matériel de guerre, armes et munitions avec mise à terre dans les ports et aérodromes français, hors cas particulier prévu par la réglementation française, dès lors qu'ils sont en provenance ou à destination d'un État non membre de l'Union européenne. Ces opérations sont soumises à la même procédure, à savoir l'obtention d'une autorisation de transit de matériel de guerre, délivrée par le ministre chargé des douanes sur la base d'un processus interministériel. Le rapport initial de la France, soumis au titre de l'article 13 du traité, ainsi que le rapport annuel au Parlement sur ses exportations d'armement contiennent des informations détaillées sur la réglementation française, ainsi que sur les procédures de contrôle mises en œuvre. Je vous remercie.
I thank you. I still have a problem with the interpretation here on this side. But let me see. Well, let me not waste time and go on to the next speaker, Switzerland.
Yes, thank you very much, facilitator. Thank you for the preparation of our discussion on Article 9, and also a special thank you for the expert presentation that we have heard right now. Such information are very useful for us to compare also our national systems to the new findings in the research. Switzerland would like to contribute the following points to the discussion. In general, we consider transshipment as part of the transit. Therefore, the same licensing requirements apply to both actions. In principle, any transit through Swiss territory, be it by land or air, needs a specific transfer license. As a landlocked country, transit regulation only applies to transit on the ground and transit through Swiss airspace. The licensing requirements are the same as for any export, which means that the transit has to comply with the same licensing criteria as an export. There is, however, one exception. A governmental flight with a diplomatic clearance is not subject to Switzerland's national licensing criteria. However, the transit through Swiss airspace with a governmental vessel needs to comply with international law, including the law of neutrality and also the Arms Trade Treaty. To countries that have an export control system comparable to Switzerland's, a general transit license may be granted. This allows for multiple transits through Swiss territory with one license. Holders of such a general transit license are required to provide accurate information about the goods that they transit, their quantity, as well as the country of destination. The holders of a general license needs to keep custom records and other relevant documents for at least 10 years. The Swiss licensing authority then regularly inspects the holder of a general license in order to ensure their compliance with the law. There are a few very specific exceptions for transit, which I do not want to explain in detail at this stage. They mostly concern hunting and sporting activities or the armed security personnel that transit Switzerland. Thank you, facilitator.
Thank you very much for that intervention, Switzerland. The next speaker is Belgium, followed by the non-violence institutional Southeast Asia. Belgium, you have the floor.
Thank you, Mr. Facilitator. And also thank you to the Secretariat for organizing today's meeting, and obviously to Diederik for his good presentation. Because it concerns your questions in the draft agenda, I want to take the opportunity to briefly share some changes that we made to the transit control system in the Flemish region of Belgium, introducing control measures concerning transit without transshipment. In that regard, I apologize if I repeat some things that Diederik already presented about Flanders from his perspective as a researcher. But in light of your questions, I think it's important to be comprehensive from my perspective as a government official. For the purpose of our expanded controls, we included the simplified definition of transit in our regulations and provided different control measures for transit with and without transshipment. The simplified transit definition now reads as follows: the transportations of goods that are exclusively brought into the territory of Belgium to be transported to another country via said territory. Transshipment in turn is understood as transit, whereby the goods are transported in one of the following ways. A, they are loaded from one mode of transport to another. And B, they are unloaded from one mode of transport and are then later reloaded onto the same mode of transport. The controls that the aforementioned Act introduced for transit without transshipment concern an ad hoc license requirement in a number of cases, which mainly concern the prohibited transfers listed in Article 6 of the Arms Trade Treaty. The first case concerns transit to countries subject to an arms embargo or similar national restrictive measures. The second concerns transit where the goods may be intended for the commission of genocide, crimes against humanity, or war crimes. The third one concerns transit that are or may be in violation of the international obligations and commitments of the Flemish region or Belgium. The fourth case concerns transit that may pose a threat to the public order, the public safety, or the essential security interests of the Flemish region or Belgium or their allies and friends. Additionally, also all transit of weapons which the production, development, or transfer is prohibited by or in accordance with the international commitments and obligations of Belgium was made subject to licensing. The newly introduced ad hoc license requirement applies when the exporter, the carrier, or any transit operator involved in the transit operation has knowledge that one of the cases subject to licensing might be applicable or is informed of this by the competent authority. The latter allows the competent authority to act if it receives information from other actors about a potential transit, like the customs authorities, the intelligence services, or even any foreign authorities. Now, the exporter, the carrier, and all transit operators, by which I mean customs agents, shipping agents, or freight forwarders, are jointly and severally responsible to comply with the relevant license requirements. And if they are located abroad, in the framework of the licensing process, they would need to be represented by a registered company in the Flemish region of Belgium. So they are jointly and severally responsible, those parties. If there are other parties involved in the transit operation than the ones I mentioned, they also have a notification duty to the competent authority if they have a reasonable suspicion that one of the cases that I mentioned are applicable. Now, when I turn to transshipment, that in turn is still subject to a systematic license requirement, but several exemptions were introduced. These exemptions are based on the end use of the goods in or by certain member states of the EU, NATO, and the Wassenaar Arrangement. In principle, though, the exempted transshipment operations could still be subjected to the same ad hoc license requirement that applies to transit without transshipments. As before, all these requirements apply to all goods on the EU military list and Wassenaar munitions list, as well as to civilian firearms and certain law enforcement materials. I hope this was relevant for today's discussion, and we will also look at updating our initial report on this point soon. Thank you.
Thank you very much, Belgium. That was very informative and to the point. Next, I give the floor to Nonviolence International Southeast Asia. You have the floor.
Thank you, Mr. Facilitator. Thank you so much for this platform, to providing this platform for Nonviolence International South Asia to put our statements into the discussion. We recognize the importance of clear transit and transshipment policies that makes full use of the whole gamut of mechanism allowed under the international law. To this end, many countries will certainly benefit from the exchanging practical solutions with one another. Each state has both shared and distinct problems and circumstances that must be taken into considerations when improving the transit and transshipment monitoring safeguards. At the very least, these safeguards must include the means to trace a shipment to allow the both flags, transit, and receiving states to act accordingly in instances of illicit activities. Bilateral and multilateral cooperation networks will be of great use to the states in regards, especially among customs and law enforcement. Nonviolence International Southeast Asia wishes to highlight once again the value of anticipating new technologically advanced means of transporting arms. The recent wider employment and development of unmanned vessels and vehicles raises questions about the responsibility and accountability and creates challenges for effective detection of tracing. Discussions regarding the transshipment must keep eye on these developments, as modes and means are long-standing issues that have been neglected in Southeast Asia and South Asia. To ensure that actions and responses to address the concern seen in risk assessments. We remain steadfast in working with the states to create effective and efficient transfer monitoring and tracing mechanisms that take into account transiting and transshipped arms. Thank you. Thank you so much, Mr. Facilitator.
Thank you. The next speaker is Republic of Korea, followed by China. Republic of Korea, you have the floor.
We can't hear the representative of the Republic of Korea. If you can unmute yourself. You are unmuted at present. Now you are okay, but we can't hear you. Mr. Wensley, I would request that we proceed to the next speaker.
Yes.
And then we can come back to the Republic of Korea.
Sure. So the next speaker is China, followed by South Africa. China, you have the floor.
感谢 facilitator， 同时也感谢秘书处为今天会议做出的周到安排。中方认真听取了 Dr. Cops 所做的详细介绍。中方认为过境和转运是防止常规武器非法转让和滥用的重要一环。赞成各缔约国加强监管力度，积极发挥各国海关的重要作用。中国海关法、海关对过境货物监管办法、海关进出境运输工具仓单管理办法等法律法规对过境和转运有专门的规定。2020年12月，中国出台出口管制法，对包括军品在内的物项出口、过境和转运的监管也作出规定。中方的政策和实践完全符合条约规定。一些发展中国家对过境和转运的监管能力仍有待提升。中方希望条约缔约国在立法、执法等方面做出努力，并开展信息交流与执法合作，加强对过境和转运环节的监管。中方愿分享经验做法，为有需要的国家提供必要协助。谢谢 facilitator。
Thank you, China. Republic of Korea, are you ready to continue? Does not seem to be the case. Next I have South Africa, followed by the UN Office on Drugs and Crime. South Africa.
Thank you, Mr. Facilitator. Let me start by wishing you a happy Freedom Day to you and all South Africans participating in this meeting. Today, 27 April 2021 marks the 27th anniversary of South Africa's first democratic elections that ushered in the democratic dispensation for South Africa and allow South Africa to take up its rightful place in the community of nations. I also would like to congratulate Sierra Leone and Togo on also celebrating their National Day today. Then I also want to thank the presenter for a very, very informative presentation. Unfortunately, Mr. Facilitator, our delegation suffered some technical difficulties yesterday and could not take the floor as planned. We have therefore incorporated some of the elements in our statement that we planned to deliver yesterday into this intervention. South Africa also would like to thank the President, Sierra Leone, for the focus of the ATT presidency in 2021 on the theme strengthening efforts to eradicate the illicit trade in small arms and light weapons and ensuring efficient stockpile management. South Africa, together with Colombia and Japan, submitted to the UNGA the resolution resolution entitled the illicit trade in small arms and light weapons in all its aspects, and would like to take this opportunity to once again thank all countries that supported the resolution. South Africa made a presentation on the South African conventional arms control systems in April 2019 at this same forum. The illicit proliferation and trade in conventional arms exacerbated by inter alia inadequate or weak control systems at the respective national levels destabilizes communities, negatively impacts security and compromises development. Such deficiency in national arms control systems runs a serious risk of being exploited by unscrupulous officials and arms dealers and brokers, waiting for opportunities to divert arms into the illicit trade. The task of adequately addressing such weaknesses and loopholes are often too insurmountable for developing countries to achieve on their own. Without assistance, it's for this reason that South Africa has traditionally strongly advocated the need for international cooperation and assistance in the full implementation of treaty obligations in the field of disarmament, non-proliferation, and arms control. The primary responsibility for controlling the flow of arms rests with the governments that allow arms to be exported, imported, and re-exported, or to transit through territories under their jurisdiction or control. All arms transfers in South Africa are governed by the National Conventional Arms Control Act of 2002, as amended in 2012. South Africa recognizes that states have an indisputable right to acquire conventional weapons for self-defense and law enforcement purposes. They also have a responsibility to do everything in their power to ensure that arms transferred by them are not used to violate human rights, to undermine development, or to commit acts of terrorism. It's for this reason that South Africa supports the efforts to establish common international standards for the import, export, and transfer of conventional arms. South Africa distinguished between the terms transit and transshipment as defined in the Customs Control Act. International transit is defined as the movement of goods not destined for South Africa, but moves through the South African customs area to its final destination. Transshipment, on the other hand, is custom procedures that allows imported goods to be transferred at a custom seaport or airport from the foreign going vessel or aircraft on which these goods are imported to another foreign going vessel or aircraft at that seaport or airport on which these goods are to be exported from South Africa. The industry is very strictly controlled, whether it's transshipment or transit, to ensure that South African conventional weapons would not be exported to destinations in a way that would counteract our domestic and foreign policies. The manufacturing, possessing, import, export, transit, or transshipment of conventional weapons are regulated in South Africa by the National Convention Arms Control Act, which inter alia ensures compliance with the policy of government in respect of arms control, ensure the implementation of a legitimate, effective, and transparent control process, foster national and international confidence in the control procedures, provide for guidelines and criteria to be used when assessing applications for permits made in terms of this act, and to ensure adherence to international treaties and agreements. In conclusion, the severe and unyielding impact of the COVID-19 pandemic on countries globally has disrupted daily life and the way of life and work as we know it. This has necessitated that we have to adopt extraordinary measures, as witnessed by the format of this meeting. South Africa expresses its gratitude to the President, Bureau, fellow members of the Management Committee, working group chairs and facilitators, as well as to the Secretariat for the hard work and tireless efforts to prepare for this preparatory meeting of state parties under these exceptional circumstances. I thank you.
Thank you, South Africa. So the next speaker on my list is the UN Office on Drugs and Crime, followed by Control Arms, which is the last speaker that I have. So the UN Office on Drugs and Crime.
Thank you very much. Good morning. Can you hear me?
Yes.
All right. So first of all, since this is the first time that the United Nations Office on Drugs and Crime is taking the floor, I would like to thank the chair of the sub-working group on Article 9, Mr. Rob Wensley, and the secretary of
This will be also.
Yeah, I think there are interferences. Can I continue?
Yes, you can. Now we can hear you.
I try. So I would like to thank the chair of the sub-working group and the secretariat of the Arms Trade Treaty for having invited us to join this important event. As the president of the Conference of State Party 7 in his working paper rightly mentioned, the ATT provisions must be implemented alongside and in connection with other relevant international and regional instruments. In the area of small arms, the transit of these items is not only regulated by the Arms Trade Treaty in a legally binding and global manner, but also by the United Nations Protocol against the illicit manufacturing of and trafficking in firearms, their parts and components and ammunition, or also called the Firearms Protocol. Comparative analysis of the interpretation of the concepts within the framework of the protocol may therefore fertilize the discussions in the context of the Arms Trade Treaty. In concrete, the Firearms Protocol requires that before issuing export licenses or authorizations for shipment of firearms, their parts and components and ammunition, each state party shall verify that the transit states have at a minimum given notice in writing prior to the shipment that they have no objection to the transit. The protocol does not define the term transit and also does not refer explicitly to transshipment, but its negotiation history may be of some interest to these discussions. During the negotiations of the protocol, there was general agreement among states that a clear definition of the concept of transit was needed, which would ensure that transit cases should generally be subject to the Firearms Protocol. Furthermore, there was a general agreement that some circumstances in which there was little or no chance of loss or diversion should be excluded. In this context, the negotiators explicitly discussed cases of shipments that flew over territories or passed through coastal waters without stopping. And I want to mention that I took careful note of Switzerland's intervention, knowing that Switzerland is extending their transit authorization system also to transit in the airspace, which is very interesting. Some delegations also argued in the negotiation phase that cases of aircrafts in transit through an airport of the state party or a ship in transit through the seaport of the state party should be excluded from the transit regulations. So these were the negotiations, but no consensus was reached with respect to those transit cases in which transferred goods would touch the soil of the transit territory, including cases of shipments that passed through or were transshipped under some form of customs control. In an early definition, because there was an early definition of transit during the negotiations, the term referred to the movement or transfer of a shipment of firearms, their parts and components and ammunition, from the territory of one state to that of another, across the territory of a third state, provided that the goods were either admitted to a place of temporary storage, undergo inward processing or economically relevant processing, or change modalities of transport. However, this definition was deleted at a later stage. Other delegations proposed to include the concept of in-transit country, referring to the country through which a shipment is moved, which is neither the country of origin nor the country of final destination. This concept also did not reach consensus. Earlier references to the term transshipment were also made, but were then deleted. In conclusion, and this is what I wanted to contribute, is that the finally adopted version of the protocol does not include a definition of the term transit. It is therefore not clear if provisions under the protocol that refer to the transit of firearms, parts and components and ammunition only apply in cases where these transferred goods are stored, processed or reloaded, or if these provisions apply to any movement across the soil of another country. Although a number of countries pointed out that this relationship between transit and transshipment would need clarification, in the end, the definition was left to the discretion of state parties to the protocol in their national implementation. I know this is not giving a response, but I hope it is useful for the discussions. Thank you very much.
Thank you to the UN Office on Drugs and Crime. So we have the last speaker on the formal list, which is Control Arms. Then we will see if we can get back to Republic of Korea. Control Arms, you have the floor.
Thank you very much for giving me the floor, Mr. Facilitator. Control Arms regrets that the COVID-19 pandemic has delayed the work of the sub-working group on Article 9. However, we welcome this new opportunity to discuss how best to manage transit and transshipment of conventional arms in the context of the ATT. Article 9 of the ATT is one of the least developed of any of the operative parts of the treaty. This is undoubtedly a reflection of the fact that not only do states' approaches to the issues of arms transit and transshipment vary according to their individual circumstances, there is a general lack of detailed understanding of the types of control regimes that exist. As a result, the sub-working group on Article 9 has a vital role to play in shining a light onto this important aspect of ATT implementation and facilitating the sharing of experience among states from different regions and in different circumstances. I want to thank the Flemish Peace Institute for their very insightful presentation. The analysis of the systems covered provides a very useful and detailed understanding of how several states parties not only define but use in practice the terms transit and transshipment. Control Arms agrees with and emphasizes Mr. Kopp's conclusion that more transparency is needed on these issues, and we look forward to the willingness of states parties and the work of this sub-working group in this regard. Control Arms, therefore, encourages transit and transshipment states to be open and proactive in sharing their experiences and the lessons they have learned in this field of operation. We hope that from these discussions, progress can be made toward the development of a compendium of existing practices or voluntary guidance on implementation of the transit and transshipment obligations under the ATT. This, in turn, should increase awareness of how effective implementation and operationalization of Article 9 can contribute meaningfully toward realizing the objectives of the ATT, including strengthening compliance with United Nations Security Council resolutions and preventing diversion of arms. Control Arms understands that while the terms transit and transshipment are clearly interlinked, there are also important differences between them. It should be noted, however, that there is no generally agreed understanding of the precise distinction between these two terms. For these purposes, Control Arms is taking transit to be the transport of goods that pass through the territory on board the original means of transport, for example, a vessel, train, or aircraft. We see transshipment as the transport of goods through a territory where the goods are unloaded from one means of transport and reloaded onto the same or a different means of transport. While there are definitional and in some cases practical distinctions between the terms transit and transshipment with regard to licensing requirements imposed by states, there is no distinction between these terms when it comes to states parties' obligations under Article 6 of the ATT. I will expand on this in Control Arms statement under topic 2. Thank you for your attention.
Thank you, Control Arms. Could we try to get the Republic of Korea back online?
Can you hear me?
Yes, we can.
Oh, Sorry for inconvenience. Thank you for giving me the floor, Mr. Chair. We'll welcome the adoption of the multi-year work plans for Article 9, and I would like to briefly share with the state parties and other stakeholders the practice and interpretation of Korean regarding transit or transshipment. The Republic of Korea provides permission for transit and transshipment based on the Foreign Trade Act and other related domestic laws. There are only 3 transit and transshipment applications for 5 years from 2016 to 2020. So there are not many transit and transshipment cases in Korea. According to our law and regulations, the term transit means that the destination of the items is a foreign country and the items go through domestic ports or airports. The term transshipment means that the destination of the items is a foreign country and the items are transferred from domestic ports or airports to other ships or aircraft. And the same rules apply to transit and transshipment according to Article 23 of Foreign Trade Act. For transit or transshipment, permission from the Minister of Trade, Industry and Energy or the head of the relevant administrative agency is required. To obtain permission for transit or transshipment, documents on the exporter, importer, and the user and a transaction contract must be submitted. In accordance with export permission standards, and the use and consignee and export possibilities to third countries are considered to determine permission. Thank you very much.
Thank you. Let's move straight into topic number 2 before we take a last round of comments, well, specifically on topic 2, and then also in general as a wrap up. Under topic 2,
Rob,
it's basically the discussion is going to be one on interpretation given by international law relating to Article 9. In this, once again, in the work plan, certain questions have been elaborated, such as how does international law define under its jurisdiction, and how do states parties approach the application of the term under its jurisdiction in their national practice.
Mr. Wednesday, if I may interrupt you, before you proceed to item number 2, we had one speaker coming from the chat room regarding the first topic. I'm just wondering if you'd want to give the floor to the state before you proceed to item number 2.
Yes, please.
We have from the chat room, Georgia, who had requested to take the platform on item number 1. Georgia, you have the floor, please.
Thank you, Mr. Facilitator, for giving me the floor. We all know that diversion of weapons can occur at different stages in country of origin, from the point of export on its routes through the transit and transshipment, and shortly after the point of the delivery in the importing state. According to the ATT assessment of the risk of diversion of exported arms is highly dependent on the exporting state and its capability to control its exports in compliance with international obligations. However, taking into consideration that diversion can take place in a long life cycle of weapons, the ATT obliges all states involved in arms transfer chain for responsible actions. In order to reduce the possibility of the arms uncontrolled proliferation to the illicit market, States are required to conduct effective licensing, risk profiling, risk assessment, and risk mitigation by customs, investigation, and appropriate law enforcement. There must be taken appropriate mitigation measures defined by the Article 11, such as close cooperation and information sharing between states, like illicit activities, including corruption, interracial trafficking routes, illicit brokers, and so on. Effective control and appropriate regulation of transit and transshipment is especially relevant for my country, for Georgia, since its strategic geopolitical location determined its growing role as transit corridor, connected Europe and Asia, and simultaneously expanded its transit potential. Georgia has 2 ports, several border crossing points, and 2 airports. But with increasing turnover of commodity, possible threat of use of Georgia's territory for illicit transactions was similarly growing. Therefore, strengthening of the legal controls on the international arms transfers, transit, and transshipment to prevent and reduce illicit proliferation is vital for us. National legislation was elaborated with high support of EU and US in the frame of the respective EU outreach programs for the partners of European neighborhood policy and US XPS program, in which Georgia has been engaged since their very beginning. The entry into force at the end of the 2014 of the new legal framework, harmonized with international legislation, was the proper basis for the implementation of the ATT provisions. We can proudly say that Georgia is the only country in the Caucasus region that is a state party of the ATT, implementing the obligations set forth by the treaty. Nowadays, Georgia has established export control system with all those components that meet the requirements of the ATT. With regard to the scope of control defined by the ATT, Georgian legislation defines 5 control regimes: export, import, transit, brokering services, and technical assistance. And as we can see, this approach is also consistent with provisions of Article 2 of the treaty. All these activities are subject to the licensing that are issued in compliance with appropriate regulations, and to carry out such activities without permits is punishable by the law. National jurisdiction determines definition of transit that is interpreted as the flow of goods through the customs territory of Georgia. Feasible control measures in accordance with international law, scope for regulated items, responsibility for compliance with regulations, assessment criteria for authorization, effective administrative provisions, and robust enforcement regimes. We don't have distinction between transit and transshipment. Transshipment is regarded as an element of subcomponent of transit and is regulated as transit in general. Transit measures apply to all items on the national control list that is similar to the EU common military list. Georgian national control system for transit goes beyond the fulfillment of obligations under the ATT Article 6 that applies to all types of transfers and all categories of products defined by the treaty, according to which state parties shall not authorize arms transfers if such transfer would violate its obligations under UNSC resolutions in arms embargoes and relevant international instruments. Especially concerning the commission of genocide, crimes against humanity, against civilian objects, or other war crimes. I should underline that the main policy and principles for Georgia's arms control implementation are definitely based on not to undermine and to contribute to international peace and security through the fulfillment of its international commitments, and not to breach international international, humanitarian, and human rights law. Authorization of each transfer by the Georgian Legislation Authority is carried out on the basis of certain criteria that are determined by the Article 7 of the treaty that shall be applied for the examination of each export and transits as well applications prior to the authorization. Ordinance of Government of Georgia, number 372, Article 3, stipulates criteria that have to be considered by the designated licensing authority, Ministry of Defense, in decision-making process. Those criteria are in full compliance with the EU common position and accordingly correspond to the requirements set forth under Article 6 and Article 7 of the treaty. This is an assessment of nature of transfer, whether it might cause a negative impact on the international situation of recipient country or on the regional or global peace and stability, the status of country of final destination with respect to the infringement of the international humanitarian norms and humanitarian law, its attitude to terrorism and respect for international law. Thank you, Mr. Facilitator.
Thank you, Georgia. Right, now let's move straight to second question, second point. And our kickoff speaker is Professor Anne Petrick. Professor Petrick holds the chair of international law and public law at the University of Basel in Switzerland. She holds a PhD in the in the field of the law of the sea and human rights law from the University of Basel, and was awarded her LLM from Harvard Law School, where she studied as a Fulbright scholar. Professor Petrick is the author of various monographs, notably pertaining to the law of the sea as well as international humanitarian human rights law, general public international law. Yes, you have the floor, Anna.
Thank you very much, Mr. Chairman, for the kind introduction and for the invitation to present today. I will share my screen. Can you see my presentation?
Yes.
Yes, excellent. So welcome to my presentation on Article 9 ATT, a law of the sea perspective. Well, why the law of the sea in the context of Article 9? Well, first of all, for practical reasons, because a significant portion of conventional weapons are shipped through the sea. And also for legal reasons. If you look at the treaty text, there are at least 3 terms where the law of the sea can be relevant, those highlighted in green. First of all, the question is, transit and transshipment through its territory, does it also cover waters or only land? The latter will hold true, and then we have to ask who has jurisdiction at sea. Is it only the coastal state or also the flag state? Has the coastal state jurisdiction over foreign ships? Last but not least, measures must be in accordance with the relevant international law. And we will see that the law of the sea limits in various ways the coastal state's ability to regulate and enforce the law at sea. Well, what is the law of the sea? Where can it be found and what types of rule does it comprise? Just a very brief introduction into the law of the sea. Where can it be found? Well, the cornerstone really is the United Nations Convention on the Law of the Sea, the UNCLOS. It's also named Constitution for the Ocean, which demonstrate its significance. There are other treaties pertaining to security, notably. There are also UN Security Council resolutions which complement or amend the law of the sea, notably on arms embargoes, and so on. But the UNCLOS is really the cornerstone, and my presentation will focus on UNCLOS. Only 186 states are parties to UNCLOS, but the principles I'm going to refer to are arguably customary international, so valid for all states. The UNCLOS, what is it about? The UNCLOS comprises two sorts of rules: substantive provisions as per the preamble relating to all issues pertaining to the sea, resources, fish, crime, environment, name it. But these provisions are not our primary interest, rather the jurisdictional provisions of UNCLOS. So what do these jurisdictional provisions of the UNCLOS comprise? There, on the one hand, are these provisions defining various maritime zones. So if we go from the land towards the sea, we first have the internal waters where you have the ports. Then there's the territorial sea. If you go further away from the coast, you have the exclusive economic zone. And last but not least, you have the high seas. Then the UNCLOS defines different types of states, categories of states. Of our interest are the port and coastal states. That's the same, a port state and the coastal state. Japan or Italy or Argentina are both port and coastal state. We usually use the name port state if we speak about ports, and coastal states if it's about the borders. Next to the port and coastal states, there are the flag states. You may know that every ship has to fly a flag, and it has the nationality of the flag state, and the law on board is the flag state law. So if it's a Swiss flag, it's Swiss law and Swiss jurisdiction on board that ship. And the law of the sea essentially says which state can do what where. So it says where port coastal states have rights and duties, where flag states have rights and duties for these different maritime zones. And we will look at this from a transit and transshipment of arms perspective. So let me start with the first zone, the internal waters. Here you see a graph with the different zones, and we speak about this zone, the internal waters, which are, if you take this baseline from which all maritime zones are measured, it's the waters landwards, where you usually have the ports. So what about these waters? Are they territory in the sense of Article 9 ATT? Well, as already mentioned, these are the waters on the landward side of the baseline, and ports are generally situated in internal waters, just at the intersection of the land territory and internal waters. And ship reach ports for transshipment or transit. Sometimes they unload or load goods, but sometimes they just reach a port without moving any goods, but just for resupplying the ship, for instance. Like land borders, seaports give access to a state's landmass, so they're kind of the logical points of control, notably for customs purposes or security purposes. What's the legal status of internal waters? Well, the UNCLOS says that the sovereignty of the port state extends to the internal waters. So they are territory, and so from an Article 9 perspective, transshipment, transit through its territory can also mean through its internal waters or ports, so no problem there. What about foreign ships? Do they have a right to access ports? Well, we have seen that it's considered to be part of the coastal state, port state's territory, so ships have no general right of access to ports. That's something which the coastal state can regulate. What about jurisdiction? This is the other term appearing in Article 9 ATT. Well, port state jurisdiction is full because we have seen internal waters fall within the sovereign territory of the port state. So the coastal state, port state can prescribe, it can regulate. For instance, it can name the conditions for port entry. It can also enforce its rules. It can deny landing, transshipment, or processing of cargo. It can deny the use of other port service. It can ultimately even board or inspect the ship in port and detain it until it complies with its law. Moreover, it can bring non-compliant ships or crew before its court and can issue penalties, namely monetary penalties. 9 ATT says that all measures must be in accordance with international law. So we have seen, in principle, the jurisdiction of the port state is full. However, there are various limitations arising under the law of the sea, either as a matter of international law or as a matter of practice or committee. Just two examples. As regards the jurisdiction to prescribe, to issue rules, the coastal state can, for instance, regulate the conditions for entry into port. However, there's a legal limitation, which is non-discrimination. It must be the same access for all ships of all states. Another example, jurisdiction to enforce against which ships are enforcement actions taken. Well, international law sets a limit. You can, for instance, not exercise enforcement jurisdiction against a sovereign immune craft, a warship or another state vessel. Further, there's a limit out of committee. The port state usually doesn't exercise jurisdiction over a foreign vessel if the matter only concerns the so-called internal affairs of the ship and do not touch the interests of the port states. For instance, labor conditions on board. That would be considered an internal matter. The port state would not interfere. An ATT violation arguably is not an internal affair of the ship, and this limitation would not apply. To sum up, for the internal waters, they are territory in the sense of 9 ATT. The jurisdiction of the port or coastal state is full. However, there are some few limits arising from the law of the sea, such as non-discrimination, or that you would not interfere with the internal affairs of a ship. With this, we come to the next zone, the territorial sea. This is, if you take the baseline again, the waters seawards the baseline. As per the UNCLOS, the territorial sea extends 12 nautical miles, that's roughly 20 kilometers seawards from the baseline, and it's important for transit because it may happen that if you want to reach from A, if you want to navigate from A to B, that you must traverse territorial seas. So it's not only about the high seas transit. What's the legal status of this part of the sea, the territorial sea? Is it also territory? Yes, according to Article 2.1 UNCLOS, the sovereignty of the coastal state extends to the territorial sea. It's like land territory, and therefore, from an Article 9 ATT perspective, transit or transshipment through its territory could also mean through its territorial waters. So this condition doesn't pose any problem. Yes, it's territory, but foreign ships have a right to innocent passage. That's very typical for the law of the sea. The law of the sea essentially balances the right of the coastal state, who wants to have sovereignty and jurisdiction over this part of the sea, and the flag state, who wants to freely navigate these waters because it's crucial for navigation and commerce, etc. So the law of the sea accords flag states, foreign ships, a right of innocent passage. What is passage? Article 18 UNCLOS defines passage. It is either navigation for the purpose of lateral passage, if you just traverse the territorial sea without reaching port, inward passage if you come from the territorial sea to a port, and outward passage if you come from the port. This passage must be continuous and expeditious. You cannot hover. What about innocence? Well, there are two criteria. First of all, Article 19 says it is no longer innocent if the passage is prejudicial to the peace, good order, or security of the coastal state. And to specify this rather abstract definition, Article 19 comprises a whole list of prejudicial activities. And among this list, you have the loading or unloading of any commodity in contravention of customs law. So activities implies it's about how the vessel behaves. It's the external conduct. It's not the cargo on board which is controlling. Not even ships carrying nuclear substances are considered in non-innocent per se. The mere fact of having arms on board does not render the passage non-innocent. It needs something more. Then you have the second criterion. Passage must be in conformity with the convention, with UNCLOS and other rules of international law. The meaning of this phraseology is not entirely clear. It could mean that you have two criteria, innocence plus compliance with other rules of international law, such as the ATT, or it could also mean that you need to define innocence in a way that it's in accordance with international law, that you would have to define innocence in line with the ATT, for instance. And here there is room for bringing the ATT or embargo resolutions of the Security Council in. What about jurisdiction? That's the other term in 9 ATT. Well, we have seen territorial sea is considered as territory where the coastal state has sovereignty. There is full jurisdiction. However, the law of the sea restrains that jurisdiction a little bit, and this brings us to Article 9 ATT condition that measures must be in accordance with international law. So, to what extent can the coastal state regulate, prescribe, and what limits arise from the right of innocent passage? Can a coastal state regulate innocent passage? Yes, he can, but he is limited. He can only regulate if it is one of the subject matters that are listed in Article 21(1) UNCLOS. And there's a bit of a debate whether the list is exhaustive or not. If it's exhaustive, the question is whether transit and transshipment are covered. This provision says that the coastal state can notably regulate to prevent an infringement of the customs and fiscal law. So it seems that here there is a niche for ATT considerations. However, in regulating, the coastal state shall not hamper innocent passage. It is notably prohibited to impose requirements which have the practical effect of denying or impairing passage, such as always demanding an authorization for passage, be it a license or permit, or to always give advance notice for passage. And of course, you cannot discriminate ships of specific states. What about enforcement jurisdiction? In principle, full jurisdiction, Article 25 says that the coastal state can take the necessary steps to prevent non-innocent passage, to implement and enforce its rules regulating passage. It can take the full range of enforcement measures. Usually it's a gradual exercise. You would request information, you would warn. Ultimately, if there is no compliance, you could interdict, board and inspect the ship, you could expel it from the territorial sea, order it into port for further investigation, etc. So to sum up the territorial sea, yes, it's considered territory in the sense of Article 9 ATT. In principle, the coastal state has full jurisdiction. However, it's limited by notably the concept of innocent passage. We have seen the law of the sea puts limits on regulation and puts limits on definition of what is innocent passage. This is the last zones we are going to cover. That's going to be very brief. The exclusive economic zone and the high seas. So if you move further away, you first have the exclusive economic zone and then the high seas. Let me start with the exclusive economic zone. It's defined as the 200 nautical miles measured from the baseline, and different from internal waters and territorial sea, which every coastal state has. It must claim an EEZ. It must establish it. And a very crucial difference, it doesn't belong to the territory of the coastal state. And the coastal state has not full jurisdiction over the area, but just functional jurisdiction over specific activities relating to resources. So a very limited jurisdiction, which doesn't seem to be relevant in the ATT context because it's not about resources, the shipment of weapons. So for Article 9 ATT purposes, transit through its territory cannot mean transit through the EEZ of a coastal state. So full stop here, we do not need to examine the other conditions as it's not territory. High seas, we have a negative definition in the UNCLOS. It's the waters beyond the territorial sea and EEZ. The UNCLOS also says that the high seas is under no state jurisdiction. It's no state's territory. So it's clearly not territory in the sense of Article 9 ATT. What about ships? It's true that every ship must have a nationality and that the flag state must exercise its full jurisdiction over that ship. But it's also very clear in doctrine that ships are not floating territories. So the same here, full stop, because Article 9 refers to territory. If we sum up, so the EEZ and high seas are not territory in the sense of Article 9, and therefore we need not to discuss about jurisdiction or any limits on the exercise of jurisdiction. A very brief summary, so territory can mean internal waters where we have the ports, it can mean territorial sea, but not EEZ and not high seas and not ships. Generally, the law of the sea says that the coastal port state has full jurisdiction, but the further we move from the coast, the weaker that jurisdiction becomes, and the more important become the limits that are put on the ability to regulate and enforce. We have seen that notably the right of innocent passage of flag states puts an important limit to the exercise of jurisdiction of the coastal state. Well, that's 9 ATT from a law of the sea perspective in a nutshell, and I'm very happy to take your questions. Thank you very much.
Thank you, Professor Petrick. At this point, before we go into general statements, may I ask if there are any comments or specific questions for Professor Petrick? Floor's open.
Rob, I confirm that there are no questions from the chat room directed to Professor Petrick. So you can continue with the list of speakers as published.
All right. Thank you. I thank you. We just have 4 speakers. That is France, Switzerland, UN Office on Drugs and Crime, and Control Arms. France, you have the floor.
Je vous remercie, monsieur le facilitateur, de me donner à nouveau la parole pour contribuer à cette deuxième partie de la discussion de ce sous-groupe. Et merci à la professeure Petrick pour sa présentation très riche et très claire. Je vais être brève car je sais que le temps presse, monsieur le facilitateur. Les termes sous sa juridiction et conformément au droit international qui figure à l'article 9 du traité visent à prendre en compte le principe de liberté de transit, ainsi que les dispositions des conventions internationales pertinentes, telles que par exemple la Convention des Nations Unies sur le droit de la mer, qu'a évoqué à l'instant la professeure. Plusieurs options peuvent être mises en œuvre par les États parties en application des dispositions de cet article 9. Ils peuvent ainsi mettre en œuvre un contrôle douanier qui se caractérise par des inspections systématiques ou ad hoc conduites au point d'entrée ou de sortie du territoire, un système de notification préalable via la communication d'informations au pays de transit afin de lui permettre, le cas échéant, d'inspecter ou de saisir la cargaison, un système d'autorisation préalable, soit par consentement implicite, soit par délivrance d'une licence de transit. C'est cette dernière option qui a été retenue par la France. Certaines opérations de transit et de transbordement sont ainsi soumises à l'obtention d'une autorisation préalable délivrée par le ministre chargé des douanes après un examen interministériel. L'autorisation délivrée a une validité de 6 mois et elle accompagne les matériels pendant leur transport en France et doit être présentée à toute réquisition des autorités habilitées. Des informations sont communiquées chaque année par la France sur les autorisations de transit transbordement délivrées dans le cadre du rapport annuel que le gouvernement français transmet chaque année au Parlement sur les exportations d'armements. Je vous remercie, monsieur le facilitateur.
Thank you, France. Give the floor to Switzerland.
Mr. Facilitator, thank you very much for giving me the floor again, and a warm thank you also for Professor Petrick for this very useful presentation. It is very helpful to have this knowledge also available for our discussion here on Article 9. As Switzerland is a landlocked country, my introduction will be rather short. Nevertheless, I would like to make the following remarks. In principle, Switzerland's jurisdiction applies to acts which take place on its territory. This also applies with regard to the transfer of arms. The Swiss legislation, however, can affect arms transfers outside of Swiss territory if they are brokered from Switzerland. This is due to the fact that brokering activities on Swiss territory are subject to a licensing regime. Swiss law governs maritime navigation under the Swiss flag in conformity with international law. Therefore, Swiss seagoing vessels may only sail under the Swiss flag, which means that on the high seas, Swiss law applies on board of Swiss seagoing vessels. But as we have heard in the expert presentation, flagships are not considered territory. The mere transport of arms by sea is not subject to Swiss export controls, even though this is a Swiss flag state. So much for our intervention. Thank you very much again, facilitator.
I thank you, Switzerland. In the second last speaker is the UN Office on Drugs and Crime.
Many thanks for giving me the floor. Excuse me. Thank you for giving me the floor. With regards to the scope of application of the provision referring to the transit of small arms, the Firearms Protocol in Article 11, security and preventive measures, contains a similar formulation than the one used in Article 9 of the Arms Trade Treaty. This said, each state party shall take appropriate measures to require the security of firearms, their parts and components and ammunition at the time of transit through its territory. The formulation follows a purely territorial understanding of the term transit, which extends the scope of application of the security and preventive measures in Article 11 of the Firearms Protocol only to those transit that cross the boundaries of the respective state party. If instead the small arms are shipped from state A to state B on a vessel that flies the flag of state C, State C would not be obliged to require the security of arms because these arms are not moved through the territory of C. The general requirements for export, import, and transit licensing or authorization systems under Article 10 of the Firearms Protocol, in contrast, are not as clear-cut and simply refer to transit states instead of the transit through their territories. However, the reference to landlocked state parties in Article 10 of the Firearms Protocol is a strong argument for a territorial interpretation of the term transit states. Hence, the regulatory requirements of the Firearms Protocol related to the transit of small arms seem only applied to transits through the territory of the respective country. From a criminal justice perspective, in contrast, the jurisdiction over cases of illicit arms transit is defined in a broader extraterritorial sense and extends to offenses that are committed on board a vessel that is flying the flag of the state party or an aircraft that is registered under the law of that state party. What sounds like an academic case study is of practical relevance. An arms dealer moves small arms on board a vessel of state A from state B through a port in state C to state D without the required export, import, and transit authorizations. This is what happens quite often. In this case, not only the states B, C, and D through which territories the arms were moved have jurisdiction over the case, but also the state A only because arms were shipped on a vessel flying the flag of state A. To close the circle, taking into account that Article 9 of the Arms Trade Treaty requires state parties to take appropriate measures to regulate the transit and transshipment of conventional arms under its jurisdiction, the Firearms Protocol provides cornerstone criminal offenses to enforce these regulatory measures, both within its territory, but also abroad within its extraterritorial jurisdiction. I will not go further into detail with regards to the regulatory aspects of the transit measures under the Firearms Protocol, since I understood that according to the multi-year work plan of the sub-working group on Article 9, this will be subject to future meetings of the working group. Many thanks for giving me the floor.
Thank you very much. The last speaker on my list is Control Arms. You have the floor.
Thank you very much again, Mr. Facilitator, for giving me the floor to share a Control Arms statement on this topic. Control Arms welcomes the consideration of the legal questions posed in topic 2 of today's session of the sub-working group on Article 9. Topic 2, as this exercise more broadly, provides a much needed space for the sharing of views on the intersection and application of Articles 6, 7, and 9 of the ATT among states parties who play a role in the transit and transshipment of conventional weapons. It also provides a forum to discuss how ATT obligations fit together with existing international legal obligations, such as the law of the sea and the right of innocent passage, and also those relating to transit by air and by land. In this regard, Control Arms encourages the sub-working group to seek out resources developed by civil society, especially the one developed by Safer World in 2015 that is available on its website, titled Prevention, Transit, and Innocent Passage under the Arms Trade Treaty. I'd also like to take this opportunity to thank the speaker for her very detailed analysis of the UNCLOS principles in regard to the ATT. As we're at the beginning of this exercise today, I will concentrate on states parties' relevant obligations under Article 6 of the treaty. The Article 6 prohibitions apply not only to exports, but to all transfers, which the ATT defines as inclusive of transit and transshipment. While the language in Article 9 appears to provide some flexibility to states with regard to how to implement obligations found in Article 6 with respect to transit and transshipment, its necessary and feasible language cannot be read as relieving states parties of their obligation to uphold the prohibitions contained in Article 6. Instead, states parties must fulfill their obligations relating to Article 6 based on a holistic interpretation of the treaty. For states parties to be in a position to fulfill their obligations under Article 6, they need to have knowledge of the type, quantity, ultimate destination, and end user of arms that are transiting or being transshipped through their jurisdiction. In this regard, it's important that states parties have in place the capability for their competent authority to be notified and provided with all relevant details of conventional arms shipments transiting or transshipping through their territory. Furthermore, faithful implementation of Article 6 requires that all ATT states parties have the legal authority to interdict and prevent the transit or transshipment of arms in line with UNCLOS principles, where they have reason to believe that the transfer violates Article 6 of the ATT. For guidance on how states parties might establish the necessary regulations and procedures, make best use of the information shared in this sub-working group, and progress towards a better understanding of best practices, we reiterate our recommendation to this sub-working group to develop a voluntary guide to implementing Article 9 of the ATT, similar to processes undertaken in other sub-working groups. Such a guide would be valuable for states that are in the process of reviewing and developing their national control regulations, systems, and procedures to ensure effective implementation of the ATT, and may thus contribute to increased effectiveness of the ATT as a whole. Finally, Mr. Facilitator, the elaboration of guidance for transit and transshipment states has the potential to make an important contribution to the ATT universalization, Many states that have not yet joined the ATT are those where transit and transshipment are key concerns. Clarifying the roles and responsibilities relating to transit and transshipment can provide much needed information and guidance on ATT implementation in this specific context. Thank you again for your attention.
Thank you, Control Arms. Just by way of wrapping up before I hand over to the Secretariat, are there any other delegations wishing to take the floor?
From our end, there is no delegation that is requested to take the floor from the chat room. So we've exhausted the list of speakers. Thank you.
All right. Okay, thank you. May I just kick off by saying that thank you for the very informative presentations, thought-provoking statements, and if you wouldn't mind emailing the presentations and statements to the ATT Secretariat, that would far more facilitate our work as we go forward. I said last year as well, we don't wish to be prescriptive, though the mandate on the work to the working group on effective treaty implementation was decided upon by states parties. That's why in Article 9, my approach has been a focus on seeing where we can reach common understanding. On topic 1, I would think that developing at this stage, my initial thinking, developing some voluntary guidelines is going to be a bit more tricky than on topic number 2. That's just my assessment. And I say that because on topic number 1, you will see when you go through the work plan, it's about national implementation, national views on what transit is, national views on transshipment, etc., or whether there's a mix of the two. I do agree with certain points made by Control Arms, not all. That's my prerogative, but I would see merit. I've always agreed that there's merit in states that are busy revising their national legislation, in national practices, in national regulations. There's always scope for us to share information to create a better worldwide system of arms control. That's about it at this stage. As for the work forward, we will take our cue from the Secretariat in conjunction with 3 facilitators. Secretariat Dumisani, is there anything else before we close?
Nothing from our side.
All right, dear delegates, thank you very much for your participation. Thank you for enriching our discussions, for enriching our debate. So I think that we can adjourn this meeting.
Thank you, Rob, for facilitating your session from Pretoria, South Africa. So we have concluded the session on Article 9. So we are happy that we had not experienced major technical challenges, despite the facilitator operating remotely. We have now reached the last hour of today, which is dedicated to the working group on treaty universalization. You'll be aware that this working group is co-chaired by the current president, Ambassador Giberi of Sierra Leone, together with the previous president, who was Ambassador Villegas of Argentina. I would like to take this opportunity then and invite the president to come to the floor in his capacity as the co-chair of the working group on treaty universalization. I realize that the president is quite colorful today, and it has been indicated that it is his national day.
I'll get to that in a moment.
Thank you so much. Mr. President, before you take over, I would want to confirm if Ambassador Villegas, who's operating remotely, can hear us and is able to join this as a co-chair. Thank you,
Yes,
Ambassador Villegas.
Dumisane, good morning.
Thank you
Can
so
hear-
much.
Okay.
I can
Thank
hear you
you.
very well. Thank you so much. Mr. President, sir.
Thank you very much, Mr. Secretary. Thank you. There was talk of how colorful we look today. There's a reason for that. Today is our national day. We gained independence from Britain on this day in 1961. I'll also like to extend fraternal greetings to our West African neighbor, Togo, and to South Africa, which also gained its Freedom Day on this day. Thank you so very much. Thank you for joining us today in this meeting on the working group on treaty universalization in the CSP7 cycle. This working group was established by CSP3 with the objective of leading the process of harmonizing ideas on the issue of treaty universalization with a view to determining the best way to take the issue forward. The preamble section of the treaty emphasizes the desirability of achieving universal adherence to this treaty. Article 17A(b) of the treaty provides that the Conference of States Parties shall, and I quote, consider and adopt recommendations regarding the implementation and operation of this treaty, in particular, the promotion of its universality. This provision obviously emphasizes promotion of treaty universality as a critical element of the treaty deserving the attention of all ATT stakeholders. In taking forward the mandate of the working group on treaty universalization, it is important that all ATT stakeholders exchange views on a continuous basis on effective approaches to promoting the universality of the treaty. Working group co-chairs have prepared and circulated a draft agenda to guide the discussions today. This draft agenda covers the following items. 1, which we've already done opening of the meeting. Number 2, updates on the working group's co-chairs activities with respect to promoting universalization of the ATT. 4, ATT Secretariat update on the status of ratifications and accessions. 5, update on efforts by states to promote the universalization of the ATT. And number 6, civil society and industry efforts to promote the universalization of ATT. I take it that delegates find the draft agenda acceptable. Distinguished delegates, without much ado, let me inform you how the co-chairs plan to facilitate today's discussions. I will facilitate agenda items 2, 4, and my co-chair, the distinguished ambassador of Argentina, Ambassador Villegas, will facilitate items 5, 6. At the conclusion of the planned agenda items for the working group, I will gracefully step aside and allow Ambassador Villegas in his national capacity to present a revised working paper Argentina submitted in the previous cycle. With the order of business for today confirmed, I will now proceed to item number 2 of the agenda and update this meeting on activities undertaken by the CSP7 presidency in promoting the universalization of the treaty. Ladies and gentlemen, Excellencies, as president of the 7th Conference of State Parties to the ATT, I have taken as of primary importance encouraging states that have not yet joined the treaty to do so at the earliest. My presidency has been determined from the start to strengthen the ATT through, among others, increasing the number of state parties fully committed to the treaty. In this regard, I would like to formally welcome Namibia, which sounds like a surprise. Namibia has actually been quite active in the cycle, but joined just a year ago. China, Sao Tome and Principe, Afghanistan, and EU, who joined the treaty last year and whose accessions and ratifications we were not able to properly celebrate at the 6th Conference of State Parties due, of course, to the COVID-19 restrictions. As I began by saying, Sierra Leone takes seriously its obligation to build on the efforts of past ATT presidents with respect to universalization and all its aspects. It has been a pleasure working with Ambassador Villegas and to benefit from his experience as my predecessor and in his efforts to support treaty universalization. Since coming into office, my presidency has undertaken a number of activities related to treaty universalization. Our first order of business, of course, was to facilitate the preparation and processing of the 2020 ATT resolution at the first committee of the United Nations General Assembly, which was supported by 150 states. This year, due, of course, to the COVID-19 pandemic measures, prohibiting in-person meetings and the current health and travel restrictions adopted by most states, I had to find creative ways to advance the treaty's universalization. I consulted very intensely with Capital, with the president of Sierra Leone, His Excellency Dr. Julius Maada Bio, and we decided that the president should write a letter to heads of states whose countries are not yet members, state parties, encourage them to join this important arms control instrument. In writing this letter, the president of Sierra Leone highlighted the universally shared goals of, and I quote the letter, preventing weapons from being illicitly traded and reducing the human cost of armed conflicts, goals that are fundamental to ATT's existence. To organize the work on universalization effectively, I adopted a strategy of prioritization, separating non-state parties into two groups. The first group includes states considered to be close to joining the treaty based on certain advancements made at the national level, including, but not limited to, signing and ratifying the treaty. And the second group being those states indicating that joining the ATT is a slightly longer prospect. Today, I brought back letters a few weeks ago from Capital, and I have personally hand-delivered my president's letter to ambassadors and permanent representatives of 24 non-state parties, including 13 states from Africa, 7 states from Asia, 1 state from Europe, 1 state from the Americas, and 2 states from Oceania. It has been a great pleasure going around all these missions here in Geneva and personally hand-delivering these letters. And it has had these extreme moments of both pleasure and pathos. The welcome has been immense, and I can't. I think I've had to consume gallons of excellent coffee at all of these missions, and one other interesting sidelight is that we have this ritual. I go around mostly with my assistant or my experts or deputy, and after long conversations, of course, the face masking is something sometimes you have to you wear, and then but you'll get your host saying, well, I mean, it's time for coffee, and that means, of course, you have to take off the face masks. And after that, we have this ritual of taking photos while I hand over these letters to colleagues. And at one point, I remember the mission I went to, we took these initial photos without face masks. And these guys said, well, now how can I send this photo out? And so we had to wear face masks again to take a different set of photos, which we hopefully circulate some of these photos at some point. But it's been a real pleasure, and the interest has been immense across the board. In speaking directly with countries concerning their progress towards joining the ATT, and where they are encountering challenges, one common theme has emerged. It emerged throughout most of my conversations with other PRs and ambassadors. One common theme is the need for cooperation and assistance. For some non-state parties, especially those in the developing countries, the prospects of cooperation and assistance in order to implement their obligations under the ATT once they join is important, expressly so. Reviewing and amending legislation establishing controls and record keeping for international transfer and receipt of weapons, and preventing diversions are obligations that require some resources and some technical expertise, which some countries necessarily may not have. Achieving the objectives of the ATT requires ensuring that all state parties have the necessary resources to effectively implement the treaty. It is one thing to sign the treaty, it is another to make sure that the treaty's provisions are properly implemented, and that's extremely important. In this regard, a key mechanism, of course, that we have is the Voluntary Trust Fund. I'm grateful to those state parties serving on the VTF committee and those that provide financial assistance to this important multilateral fund in support of the treaty's implementation. In addition to that concern, during the course of my engagement, some countries expressed reservations about joining the treaty on the following grounds. Number one, they live in volatile environments and the security concerns posed by adjacent countries that have not yet joined. There was quite a lot of talk about that, especially in the North African, Middle Eastern regions. Number two, there have been bureaucratic hurdles, particularly changes in the composition of the legislature and key executive offices, delaying the domestic ratification process. We have had a few interesting examples. Two letters addressed to particular heads of states had to be modified because there were changes in the top leadership of those countries. And number three, there's a view which at every opportunity I try to debunk, that the treaty would impair the ability to acquire arms for legitimate national defense purposes. These challenges, of course, have been compounded by the ongoing pandemic, which will have long-term socioeconomic and political impacts on many countries. Against this background, and given that the universalization of the treaty is a shared responsibility of all state parties, I call on you to adopt measures and support efforts to promote the treaty's universalization in whatever way you can. Where such measures could be adopted at individual national capacity levels, bilaterally and in regional groupings, I encourage you to do so. Sierra Leone and Argentina, in our capacity as co-chairs of this group on treaty universalization, will continue to lead these efforts. If any delegation wishes to engage in the work of the ATT universalization, please feel free to approach us and we'll be most happy to share our experiences with you. I must mention one other concern expressed by a non-state party. It has to do with that state party being subject to an arms embargo, and that came up. I mean, that concern is completely unanswerable, and we had interesting discussions around it without any real approach to it. I thank you all for listening to me. I would like to now invite Ambassador Villegas to update the meeting about the treaty universalization activities undertaken by Argentina in its capacity as co-chair of this working group. Ambassador Villegas, please.
Thank you, President. Can you hear me well?
Very well, Ambassador.
Okay, thank you. Good afternoon. Thank you very much. And congratulations to Sierra Leone, Togo, and South Africa for your National Day. And it's a very joyful moment for any nation. It gives me great pleasure to see all of you again, and at least through this virtual platform, and to keep on working together with Ambassador Berry towards the universalization of the treaty. Without further ado, let me inform you that at the beginning of March, Ambassador Berry and I, as co-chairs of this working group, had a meeting with the permanent representative of a country that plays a key role in the international arms trade system. The goal of the meeting was to approach this country and explore its interest to join the ATT. My conclusion about this first approach is that the meeting was positive because it gave us the possibility to have an open and transparent exchange of views about the current multilateral agenda and the important role that the ATT plays in it. At this stage, Ambassador Berry and I are looking forward to receiving additional feedback from this country on their considerations about the working group on the treaty universalization co-chair's invitation. Hopefully, before the CSP7, we will have this news, and we will maintain the ATT community duly informed. Thank you.
Thank you very much, Ambassador Villegas. Thank you. Distinguished delegates, at this stage, I would like to proceed to item 4 of the agenda and invite the head of the ATT Secretariat to give us an overview presentation on the status of ATT ratifications and accessions. Mr. Dumisani, please.
Thank you, Mr. President, co-chair of the working group on treaty universalization, as well as Ambassador Villegas, the other co-chair of the working group. We are happy to be invited by this working group, as it has become the norm to share with delegates the status of participation in the ATT. We have always followed a very clear pattern in presenting the status of participation. Normally, our presentation covers basically 4 points, which I'm going to summarize. One of it is we look at our participation from a global perspective in terms of how many states are participating at the global level. And we look at the regional perspective in terms of the breakdown in the regions. And also we look at the distribution of states versus states parties, because that element is important as well. I think the last part of the presentation will therefore address what we've come to describe as the rate at which states become states parties, which is very interesting because we see some trends and changes as the states move along. I am trying to. All right, thank you so much. Something happened and I couldn't see the first slide come on board. I think delegates can see what we have on the board. And I think, firstly, we have at this point in time, 110 states parties, as you will be aware. We've got 110 states parties. You recall that when I last gave the presentation in February last year, we had 105 states parties. Since that time to date, so we have grown by 5 additional states parties. Mr. President, you have indicated who those states are. I will take the opportunity to just restate those states. We had Namibia coming in April last year, 2020, China in July, Sao Tome and Principe in July as well, Afghanistan, July last year. And we had the last one, Niue, coming in or becoming a state party in August last year. So it was a group of states almost becoming states parties almost at the same time. That was a very interesting time that we had at that time. We do hope that this pattern can proceed as we go along. The 110 states parties that we have at this point in time would comprise of different categories of states depending on how they have joined the ATT. For instance, some have signed and ratified. A total of them is 95. Those others have signed and approved. There's 2 of those states that have done so. And others have accepted the treaty after signing it, and there are 2 of them. And the difference between whether it's ratified, approved, or accepted is determined by the constitutional arrangement of states. Others would ratify, but others would approve or accept. So that is the function of constitutional arrangement in any given state. But interestingly, we have states that have acceded to the treaty. There's 11 of them. You'll be aware, delegates, that normally the opportunity of signing a treaty, that window closes when a treaty comes into force. And this treaty, the ATT, came into force in December 2014. And at that time, therefore, you cannot, if you have not yet signed it, you cannot sign the treaty, but you can just accede to the treaty and become a fully fledged state parties. So 110 states parties, but we also have another group of states who have signed the ATT, but have not yet ratified, accepted, or approved the ATT. There's 31 states who have yet to ratify the treaty and become fully fledged states parties. And we include in that category one additional state, or one state which had signed the ATT, but it indicated at some point that they hold no intention of becoming a state party to the treaty. Of course, that is subject to changes as we move forward. But out of that, we've got 54 member states, UN member states who have not yet joined the ATT. There's 54 of them. On the right of the presentation, what I have is a pie chart which reflects this participation in a pie chart format. We haven't been doing this presentation for about a year now. We might have forgotten about the color coding. So let's go back to that. The color green represents states that have become states parties, and the color orange, in my eyes, are the states that have signed the ATT but have yet to become states parties. And 54 of them then, the red color, represent those that they still have to join the ATT. A part of the discussion that we have normally with the co-chairs of this working group is about the object and purpose of this working group, which is that of exchanging views and ideas and thoughts about the approaches to the ATT in terms of promoting its universality. And what the graph on the board shows us now basically is it demonstrates that there's still some work to be done. Yes, we are happy that about 56% of UN member states have become states parties, but we still have some distance to cover, because I think the grand objective is to have the whole pie chart turning into green. In terms of distribution of states, the charts that you see on the board at the present moment, the one on the right or on the left is a distribution of states by region. That is basically UN member states by region. And on the right then is distribution of states parties per region. Very interestingly, you would see if you look on the left, that as an example, you've got 22 or 22% of UN member states are from the region Europe, as an example. 28 are from Africa, 28% of the UN member states are from the African region, and so forth, and so forth. But if you go to the right and just try to look at that and say, look, out of this representation, how many states parties are there in this region as they are spread? What you therefore see is some changes, a little bit of, they are not fully aligned. What we see on the right is, as an example, is that 35% of our states parties to the ATT are coming from the European region, which is possibly the one with the most states parties. But conversely, as you can see, on the left, we've indicated that Asia constitute about 25% of the UN membership. But if you go to the right, you therefore see that in Asia, there's only 9% of states parties. So these numbers tell a story. And the story is, it tells us how best we can target and focus our universalization efforts. Because I think it's very clear that you can only target them better if you go to the areas where there's still an opportunity for the growth of the treaty. The next slide is about the regional perspective. Go to the regions and see what happens in the regions. And of course, you see different dynamics and different characteristic in different regions. I take Africa as the first one on the left. I'm not biased, Mr. President, to where you come from and where I come from, but it's just to indicate that, as an example, you have 52% of states in that region being states parties. It's a good fit, 52%, but they still others who still have 22% are still yet to ratify the treaty. And you also have got another percentage that is still not even close to the ATT. So it means there is opportunity for the growth of the ATT in that region in terms of reaching out to those different colors other than green. In Americas, there's a bigger percentage of state parties standing at 77%, but there's still some states which create an opportunity for growth. Asia has got the most states that are not yet party to the ATT. So basically, as I was saying, universalization efforts can be best directed there to grow the ATT. Europe has got 91%. That is the biggest region or the region with the most states parties. And Oceania has got 40% of states parties, but of course there are others that are still in the different categories, either signatory states and others have not yet joined the ATT. So, but this gives a picture of how we can better target our efforts. And the last two slides, Mr. President, or co-chairs of this working group, looks at the participation, the rate at which states become states parties to the ATT. You'll be reminded that the ATT was negotiated within the framework of the United Nations, and it was adopted by the UN General Assembly in April of 2014. That's the date when it was adopted. And of course, then in accordance with the provisions of the treaty, it came into force on the 24th of December. That is when it came into force. But maybe one step back is that on the 3rd of June, after it was adopted, it opened up for signature. So states can start to join, to sign up for the ATT. And there's quite a number of states that have signed up for the ATT. And that is why then when on the 24th of December, when it came into force, it had reached a threshold of 50 states parties. So which was states who have signed it, which makes it quite interesting. But then if you take June, when it opened up for signature, June 2014, and you move to another year, which is June, maybe let me say June 2013, and then to June 2014. All right, maybe I'm getting my slides a little bit tricky here, but all that I want to convey here is that if we were to take the time when the ATT opened for signature, that is a baseline, and move a year to the right, and you count that as a year, and you use the same methodology to go forward. What you do see is that most states became states parties to the ATT in the first 3 years of the ATT, as you can see. In the first year, according to this calculus, there were 32 states that became state parties. And in the second year, there were 37 that became state parties. And in the third year, there were 16 that became state parties. That can be explained against the reason that after negotiations, many states were committed to the ATT. And of course, then they just needed to go through the initial processes and just become fully fledged state parties. But if you move to year number 4, you start to see the area of heavy lifting in terms of promotion, because I think constitutional obligations that states had to go through, those who were committed at the beginning, I think they've had time to conclude them. But from year number 4, that is when we start to see the results, in my view, of universalization. And you can see therefore in year number 4, there were 7 states parties, 7 states that became state parties. And in year 5, there were 3. And in year number 6, there were 7. And last year, the year that we were in, there were 4 states that became state parties, according to this calculus. And the last year, which is the current year, that's why we're indicating that in yellow. We have 4 up to this far. And of course, then I normally hear co-chair, previous presidents have always had an interesting discussion about these numbers. Who had the most colorful year? To use that word, but I'm just saying, look, we are not trying. We understand that these things take some time to happen, but it will be interesting whether under your dispensation, Mr. President, we can see the numbers growing beyond 4. But it's, of course, it will be a function of how your efforts are pushing forward. Not only yourself, but the Secretariat and all states parties. It's a joint responsibility.
The challenge is embraced.
Yes. And the last slide is about the rate of participation at which states became state parties at a regional level. And again, you can see that in the first year, most of the states that became state parties were coming from largely two regions, as you can see. You had Europe leading that. But of course, as you move to the right, you start to see that in the subsequent years, you started to have other regions gradually coming forward. But all of that is a demonstration of the efforts that have been undertaken by all office holders, by all state parties, and by all other stakeholders who have got a very committed interest in the ATT. Mr. President and co-chairs of the working group, this is a reflection of the status of participation in the ATT at present. And I thank you so much for the opportunity, and I hand over to you.
Thank you very much. Thank you, Mr. Secretary. Thank you for the overview. It is both an inspiring but also big picture. I'm glad that you bracketed our region, Africa. I can even further make another distinction. In West Africa, we have only one country that hasn't yet joined, and I have strong indications that we may get that country to fully participate, hopefully in the coming months or year. I have made, as president, I've made a direct appeal to my African colleagues, African ambassadors, to be more participatory, and I've done that with other regions as well. But this is a real challenge, and I would like to, from this podium again, make this challenge to Africa, to other regions that have not yet joined, to kindly consider doing so, because participation will increase, will enrich the conversation. Thank you so very much. Distinguished delegates, I would like to hand over now to my co-chair to moderate the rest of the agenda items for this meeting. In the meantime, I would like to thank you for your attention and cooperation. I'm hoping that, Mr. Secretary, I will have to, Mr. Secretary, I would like to hand over podium to you and my co-chair, and I will kindly.
Thank you, Mr. President. If I can just hand over the reins to Ambassador Villegas. And I think the President would remain in place until we have concluded the agenda items for this. And after which then we can have Argentina presenting their paper in a national capacity. But for now, the co-chairs would remain in place. Ambassador Villegas, please.
Thank you very much. Because of the time constraints that we have, only an hour for this whole meeting. Without further ado, I would like to move to agenda item 5, the update on efforts by states on the universalization of ATT. The first 3 countries that I have on my list of speakers are China, Japan, and Mexico. So please, China, the delegation of China, you have the floor.
Merci, Monsieur le Président. 好，感谢主席。首先，中方祝贺塞拉利昂国庆60周年，南非自由日27周年，多哥国庆61周年。塞拉利昂、南非和多哥是首批签约和批约的国家，是各方的榜样。中方感谢塞拉利昂和阿根廷主席在过去1年中所做的工作。中方注意到，条约宗旨和目标正得到越来越多国家的认同，缔约国数量已经达到了110个，普遍性不断提升。另一方面，一些重要的武器贸易国尚未入约。最大的常规武器出口国美国不仅没有批约，还开历史倒车，撤销了对条约的签署。中方注意到，今天美方代表以观察员身份参加了此次会议，呼吁美方纠正错误做法，尽快重返条约。同时，我们也呼吁其他国家积极考虑入约。中方愿同各缔约国一道，积极促进提高条约的普遍性和有效性。同时，我们也理解一些发展中国家在履约方面可能面临一些现实的能力、技术、资金等方面的困难。中方呼吁有能力的国家加强面向发展中国家的外联活动、国际合作与援助，帮助有需要的国家增强入约意愿，加强履约能力建设，为吸引更多国家入约，促进各国有效履约发挥积极作用。谢谢主席先生。
Thank you to the delegation of China. And now I give the floor to the delegation of Japan. You have the floor.
Thank you, Excellency, for giving us the floor. I hope you can hear me well. Japan would like to express its gratitude to Ambassador Gberi and Ambassador Villegas for the serious efforts you have made and activities you have conducted towards treaty universalization as co-chairs of the working group. When Japan co-chaired this working group during the CSP4 and CSP5 cycles, we often heard from non-state parties that documents on the significance of the ATT in their own languages would be instrumental to engage their national stakeholders in the path towards joining the treaty. Those voices actually led to the adoption of the universalization toolkit and the welcome pack at CSP5. Again, we welcome that these documents were translated into the UN official languages, and with the initiative of the Republic of Korea, funding has been secured for the ongoing translation into 10 Asian languages. As expressed several times, Japan places great importance on the universalization of the ATT especially universalization in the Asian region. Last year, we were pleased to co-host the Asia Pacific Universalization Roundtable, again on the occasion of the CSP, together with Australia, New Zealand, the Republic of Korea, and control arms. Another example of our contribution to universalization is in 2018, when the then ambassador to the Conference on Disarmament, Nobushige Takamizawa, in his keynote speech at our annual Asian Export Control Seminar in Tokyo, spoke on the role of the ATT in prevention of terrorism and called for the Asian states' involvement in the ATT. Japan also has been taking the opportunities of bilateral dialogues to call for ratification or accession to the ATT. It has been more than a year since we last met in this working group in February 2020, and Japan would like to welcome that during those 14 months, 5 states, as mentioned earlier, Namibia, China, Sao Tome and Principe, Afghanistan, and Niue have submitted the necessary instruments and become states parties to the ATT. On this occasion, Japan would like to encourage all non-states parties, including signatory states and observer states, to join the treaty as soon as possible. We would also like to express our commitment to our continuous contribution to the universalization of the ATT. Thank you.
Thank you very much. And now I give the floor a la delegación de México.
Gracias, señor presidente, por concederme el uso de la palabra. Primeramente quisiera felicitar a Sierra Leona, Togo y Sudáfrica por la celebración de su Día Nacional. En interés del tiempo, señor presidente, abreviaré la intervención que tenemos preparada para este segmento. Primeramente, agradecemos al secretariado por la detallada presentación sobre el estado de las ratificaciones y adhesiones al tratado. Y mi delegación también.
Could we request that you turn on your microphone, please? The interpreters can't hear you.
It's already turned on. Perhaps if I put it here, they might be able to hear me well. Could you please confirm?
We can hear you from outside. I don't. Interpreters, can you hear? Can you hear him?
The interpreters can hear now.
Thank you. Thank you so much. You can
No
proceed.
worries. Thank you. I'll switch back to Spanish. Gracias. Nuevamente, mi delegación desea agradecer a Sierra Leona y a Argentina por la conducción de los trabajos de este grupo. Y como el secretariado dejó claramente expuesto en su presentación.
אני גם מתכתב עם עופר וכל החבר'ה, וגם אם זה... אז תכתבי לי בשם...
I think there somebody has their microphone on. Okay, I'll proceed. Thank you again. Switch back to Spanish. Como el secretariado dejó claramente expuesto, si bien hoy somos 110 estados parte, mi delegación observa con preocupación que la tasa de universalización del tratado en los últimos años muestra una tendencia descendente. En este sentido, es prioritario que todos los estados parte y actores interesados contribuyamos activamente a que el proceso de universalización no se detenga, a que se mantenga la moral y el interés de los participantes y a seguir construyendo los incentivos para adherirse. Los estados parte y demás actores interesados debemos aumentar el nivel de ambición en materia de universalización, orientándose a acciones y herramientas dirigidas a abordar las tendencias negativas que se vayan identificando en torno a la universalización. Asimismo, los estados parte podrían priorizar en sus contactos e intercambios bilaterales, regionales y multilaterales, como ya lo expuso el presidente, la promoción del tratado y, de ser posible, ofrecer y proporcionar apoyo y orientación para la adopción e implementación del tratado, lo cual podría incluir acciones dirigidas a sensibilizar a los parlamentos de los países que están en vías de firmarlo o ratificarlo. Señor presidente y distinguidos delegados, estas labores podrían tener mayor efectividad si van acompañadas de apoyo político o financiero de los gobiernos de los estados parte a las diversas organizaciones de la sociedad civil que se esfuerzan en lograr más adherencias al tratado. Mi delegación desea finalizar su intervención manifestando su apoyo al documento presentado por Argentina en su calidad de presidente de la Sexta Conferencia de Estados Parte, cuya actualización nos parece oportuna y sus recomendaciones son relevantes para el mejoramiento de la transparencia y el intercambio de información en el tratado. La transparencia y el intercambio de información permiten evitar las transferencias ilícitas y por lo tanto a prevenir y contrarrestar el desvío y el tráfico ilícito de armas y municiones, un fenómeno que ha contribuido a la generación de violencia, al incremento del poder de las organizaciones criminales y como consecuencia final a la afectación de la cohesión social y de las oportunidades de desarrollo de las personas. México seguirá apoyando el trabajo en torno a todos estos temas con miras a la celebración de la próxima conferencia de las partes y agradece a Sierra Leona por su liderazgo en este proceso. Muchas gracias, presidente.
Muchas gracias a la delegación de México. And now I give the floor to the delegation of Panamá. Panamá tiene la palabra.
Gracias, señor presidente. Agradecemos a los copresidentes del Grupo de Trabajo sobre Universalización del Tratado, Argentina y Sierra Leona, por su dedicación y liderazgo en las actividades que están impulsando durante este periodo intersesional con miras a aumentar el número de Estados partes en el Tratado sobre el Comercio de Armas. Tomamos nota de la actualización a cargo de la Secretaría de la ATT sobre el estado de las ratificaciones y adhesiones y hacemos un llamado a los estados que no son partes a que consideren ratificarlo sin dilación. Si bien los números son alentadores, somos de la opinión de que los diálogos para aumentar el número de ratificaciones deben centrarse en los grandes productores, exportadores y receptores de armas convencionales y en aquellas regiones donde se han registrado pocas ratificaciones, sobre todo aquellos países que aún mantienen pendientes sus procesos de ratificación y adhesión. De igual manera, es vital que la comunidad internacional perciba al ATT como un instrumento completamente funcional y con resultados positivos en la consecución de los propósitos para los cuales fue concebido. Señor presidente, Panamá reconoce la importancia del ATT como una herramienta fundamental para regular el comercio internacional de armas, prevenir el desvío de armas y municiones hacia los conflictos armados, las redes de delincuencia organizada o grupos terroristas y reducir el sufrimiento humano, contribuyendo de esta manera con la paz y la seguridad internacional, el desarrollo sostenible y el respeto a los derechos humanos. Respaldamos firmemente todos los esfuerzos internacionales para cumplir con este objetivo primordial y en ese sentido agradecemos especialmente al Comité Internacional de la Cruz Roja, los parlamentarios y las organizaciones de la sociedad civil, quienes desempeñan un papel clave en la promoción de la universalización del tratado. Esta debe ser una tarea prioritaria para todos y debemos aprovechar cada espacio para visibilizar y crear conciencia sobre los beneficios del ATT, incluso en las agendas bilaterales, regionales y globales, así como en eventos de alto nivel. Panamá contribuye con esta meta a través del mecanismo del examen periódico universal del Consejo de Derechos Humanos. Desde la sexta conferencia de Estados partes, hemos recomendado a Libia, Myanmar, Nepal y Omán para que valoren positivamente ratificar el ATT. Mi delegación se compromete a continuar impulsando la universalización del ATT en ese ámbito y esperamos que gestiones como esta puedan traducirse en resultados tangibles. Muchas gracias.
Muchas gracias a la delegación de Panamá. And now I give the floor to the delegation of the Philippines. You have the floor. Delegation of the Philippines, you have the floor. Yes.
Mr. Chair, Excellencies, distinguished delegates, ladies and gentlemen, good evening from here in the Philippines. The Philippines wishes to extend its appreciation to the President and the entire team for convening this year's working group meetings and informal preparatory meetings for the CSP7 and looks forward to meaningful and fruitful discussions on the important elements of the Arms Trade Treaty. The Philippines signed the ATT on 25 September 2013 as it is one with the international community in underlining the need to prevent and eradicate the illicit trade in conventional arms and to prevent their diversion to the illicit market or for unauthorized end use and end users. And in recognizing the security, social, economic, and humanitarian consequences of the illicit trade and unregulated trade in conventional arms. As a signatory state to the ATT, the Philippines is cognizant of its obligation to refrain in good faith from acts that would defeat the object and purpose of the treaty. To this end, our office, the Office of the Special Envoy on Transnational Crime, and other relevant Philippine government agencies, especially our Strategic Trade Management Office, are unwavering and have been in regular consultations with each other in harmonizing the implementation of local laws which mirror the objectives of the ATT and in ensuring that the needs of the ATT are achieved, pending conclusion of the ratification process. Furthermore, we have been in constant discussions in the establishment of an integrated strategic goods database to improve our coordination and info sharing. The Philippines has also conducted various activities aimed at deepening our understanding on the implementation and best practices of this important treaty. An example is the national webinar on the ATT organized with the support of the European Union through Expertise France on 27 October 2020, with over 40 representatives from various Philippine agencies and civil society groups in attendance. About the ratification package, the instrument was recently being transmitted back to our Senate, this being part of the due process which we have to redo for instruments like the ATT each time we have a new Senate. But we are getting there, I assure you, Mr. Chair. I just want to bring up what Mr. Dadla have also noticed in the ATT's universalization in one of those pie charts that he presented, the disparity between the number of states against the number of states parties, which is quite pronounced in Asia. Why the disparity compared to all the other regions? Maybe there is just a need to shift our efforts to Asia, or maybe we have focused so much to all other regions except Asia. Maybe most of Asia thinks ATT is not a priority while the other countries think otherwise. Well, we can't really tell unless we will check. In closing, the Philippines hereby underscores that it remains committed more than ever to the immediate ratification of the Arms Trade Treaty in our effort at preventing diversion of arms and reducing human suffering. Thank you, Mr. Chair, for this opportunity.
Thank you very much, and greetings from Geneva, and thank you for your participation. Now I give the floor to the European Union. You have the floor.
Muchas gracias.
Sorry, and thank you, the interpreters, because they are giving us 15 extra minutes. Thank you. You have the floor.
I'll try to be quick. Muchas gracias, Embajador Villegas. Let me also at the outset congratulate Sierra Leone on their Independence Day and Togo and South Africa on their National Days. Also, congratulations, Ambassador Jberi, on your beautiful, colorful outfit. Actually, to be honest, I should have also wore something special because today is also the National Day of the Netherlands. It's the birthday of our king, which we celebrate widely in the Netherlands. So I should have worn something orange, the color of the royal family. However, I'm here representing not the Netherlands alone, but the European Union as a whole. So for that reason, I'm just wearing my usual boring tie and suit. With that being said, Mr. President, I have the honor to speak, as I mentioned, on behalf of the European Union and its member states. The candidate countries Turkey, Montenegro, Serbia, and Albania, as well as the Republic of Moldova, aligned themselves with this statement. At the outset, we want to thank you, Ambassador Jberi, Mr. President, for carrying out this important intercessional work and for your leadership during your presidency, in particular in sending out the letter from your president to states not yet parties to the ATT. These are exceptional times, and therefore your efforts to promote the ATT in its universalization are challenging for all. Your efforts in this regard are even more appreciated, therefore. We want to thank the representatives of civil society, many of whom are with us today, for their relentless dedication to promoting the ATT. Civil society organizations continued over the past year to sustain targeted activities at national and regional levels in support of ATT universalization, providing targeted advocacy and information sharing, as well as public pressure to maintain the prioritization of the treaty on states' political agendas. We would particularly like to welcome those state parties that ratified or acceded to the treaty in the last year: Namibia, China, Sao Tome and Principe, Afghanistan, and Niue. Your accession is proof of the continuous and increasing relevance of the ATT and brings full universalization of our commonly agreed norms a step closer. Mr. President, it is our common goal to establish the highest standards of the international trade in conventional arms and to prevent and eradicate the illicit trade in conventional arms and ammunition and prevent their diversion. We reiterate here our call on UN member states, especially the major arms importers, exporters, and transit states, to sign, ratify, or accede to the ATT without further delay. The EU urges others to increase our collective engagement and outreach efforts to non-states parties, underlining the benefits of joining the ATT and thus contributing to international and regional peace and stability. We are reasonably encouraged with ATT universalization progress to date. Nevertheless, we continue to believe that more can be done. The EU and its member states continue to play an active role in ATT universalization efforts through the various EU outreach programs and in our bilateral dialogues on disarmament, non-proliferation, and arms control. In addition, finally, we are pleased to announce that we will fund the publication of the ATT Universalization Toolkit. As mentioned by Japan, the Universalization Toolkit was prepared by the ATT Working Group on Treaty Universalization and was adopted by the states parties at the 5th Conference of States Parties to the ATT in August 2019. With the printing of this toolkit in a brochure ahead of the 7th Conference of States Parties, we joined the initiative of the Republic of Korea that translated this toolkit into the several UN languages. We hope that the printed version of the toolkit will be further used in universalization outreach activities and will help our collective ambition. Thank you, Mr. President.
Thank you very much. And now I give the floor to the Republic of Korea. You have the floor.
Thank you for giving me the floor, Ambassador. I would like to express my profound gratitude to co-chairs of the Working Group on Treaty Universalization and the Secretariat for their efforts in universalization of the ATT despite the difficulties of the COVID-19 pandemic. I would like to share the Republic of Korea's effort to promote the universalization of the ATT. Last year, we completed the project translating the Treaty Universalization Toolkit and the Welcome Pack into 10 Asian languages, which was recommended in the CSP5, where the Treaty Universalization Toolkit and the Welcome Pack were adopted. Adding to the efforts of the Secretariat, the co-chairs of the Working Group on Treaty Universalization and other regional activities supported by civil societies. We posted those translated documents on the ATT website with the assistance of the Secretariat, and we hope that all stakeholders will find this useful for their own bilateral and multilateral outreach activities. We will continue to work on the universalization efforts, and we are open to any ideas and suggestions for furthering the use of these translated documents. Thank you very much.
Thank you very much. Y ahora tiene la palabra la delegación de Argentina desde Buenos Aires. Argentina tiene la palabra.
Muchas gracias, señor presidente. La universalización es uno de los pilares fundamentales del tratado. En particular, quisiéramos destacar la importancia otorgada al ATT en la agenda de grupos de trabajo como el de armas y fuego y municiones del Mercosur y Estados asociados, que otorga espacios para discutir las implementaciones nacionales del tratado, así como la posibilidad de desarrollar medidas y proyectos conjuntos a nivel subregional. Argentina se compromete a continuar impulsando la inclusión del ATT en las agendas de este ámbito, como en otros, regionales y globales. Del mismo modo, resulta relevante explorar las sinergias y complementariedades con otros mecanismos relativos al comercio y el tráfico ilícito de armas. Actualmente, el grupo de expertos gubernamentales de las Naciones Unidas en municiones convencionales, como foro complementario del UNPOA, ha elaborado recomendaciones para el secretario general de la ONU, en las que se ha remarcado la necesidad de explorar sinergias con otros foros, como el ATT, promoviéndose la necesidad de un documento flexible, inclusivo y que tome lecciones aprendidas del proceso que tiene lugar en el marco del Tratado sobre Comercio de Armas. A este respecto, dada la universalidad del UNPOA, podría resultar beneficioso promocionar el ATT entre los países que expresen interés en fortalecer sus capacidades nacionales en control de transferencia. Muchas gracias, señor presidente.
Muchas gracias, Argentina. And now I give the floor to the last speaker in this item, Germany. You have the floor, sir. Germany.
Thank you, Mr. Chairman. I couldn't hear you well. I suspect you gave me the floor. Federico, yes.
Yes, exactly.
Thank you very much. Since time is very, very short, I'll be very brief. First, Germany would like to align itself with the statement just delivered by the European Union, and I would really like to thank the President and you for the untiring efforts you've been undertaking to broaden participation in the ATT. And like my colleague from the EU, I would also like to welcome the new states parties to the treaty. Nationally, we have, like the European Union, used bilateral encounters to promote universality, and we are continuing our practical efforts through our export office, the BAFA. As so lucidly outlined by the Secretary Dumizani Dladla, and I'd like to thank you for your presentation very much. We have had quite some success in reaching universality initially in particular, but accession rates have slowed over the past years. So we clearly need to do more in order to bring accession rates back to the earlier levels, in particular in what I may call, say, blanker spots on the globe. One possibility we as states parties have would be to increase burden sharing among us and particularly coordinate our efforts even more than it's been happening. For that purposes and other purposes, or other ideas which I don't want to go into right now because of a lack of time, it may be useful, Mr. Chairman, that we consider one or even several informal meetings on universality here in Geneva in the time before we go into the next conference of the states parties. So with that, I thank you for giving me the floor. Thank you, Mr. Chairman.
Dankeschön, and thank you very much. And indeed, we need more ideas on universalization. So thank you for that proposal also. This was the last speaker on item 5. We have few minutes. We will try to do our best to exhaust the agenda. And now we move to agenda item 6, which is civil society and industry efforts to promote the universalization of ATT. And I have control arms in my list of the speakers.
Well, thank you very much. Thank you very much, Mr. Chairman. Can you actually hear me?
Perfectly, sound and clear.
Okay, great, thanks. Well, congratulations to Ambassador Djibouti and to you, Ambassador Villegas, on your ongoing efforts and working with states to join the ATT. In the time available, I'll just deliver a much shorter statement, and we'll make our longer statement available in writing. And we very much agree with Germany that, in this area, more ideas are needed, and that the idea of informal exchanges is a good one. In its work to strengthen the reach of the ATT, Control Arms is particularly focused on highlighting the benefits of treaty accession in the Asia Pacific, Middle East and North Africa and Sub-Saharan African regions. The ongoing violence in Myanmar is but one of a number of reasons that Control Arms is encouraging ASEAN states to become more informed on the work of the ATT, its benefits on both the national and regional levels, and to provide assistance to other states in the sub-region seeking to join and implement the treaty. And in this regard, we very much welcome the statement by Philippines and agree that there needs to be a much stronger focus on Asia in general. We also look forward to co-hosting with Australia, Japan and New Zealand in June this year, the 3rd annual roundtable on ATT universalisation in the Asia Pacific region. We very much welcome all of those states parties that joined last year, and would like to make a particular reference to China. We are pleased to hear of China's commitment to rigorously regulating all military goods through the development of comprehensive national legislation as set out in its statement of yesterday during the sub-working group on Articles 6 and 7. We were also pleased to hear that China has started to apply the ATT criterion to all exports since becoming an official state party. We look forward to learning more about how China is organising its compliance with the treaty and how this might help to drive forward treaty membership and implementation of states. In the MENA region, Control Arms will continue to highlight the positive work being carried out by national and local civil society organisations. While in Sub-Saharan Africa, Control Arms is planning 2 ATT Academy trainings, one for Southern Africa in partnership with Namibia and another for Indian Ocean states in partnership with Madagascar. Both of these comprehensive technical training programs on the universalisation and implementation of the ATT are made possible with the support from the ATT Voluntary Trust Fund. While the timing of the 2 ATT Academy trainings remains uncertain due to COVID-19 restrictions, we appreciate the ongoing understanding and flexibility of the VTF, and we look forward to moving ahead with these programs as soon as possible, as soon as feasible. So thank you very much once again, and we look forward to working with all states parties and stakeholders on what remains a key issue. Thank you.
Thank you very much. I understand there are no more speakers under this agenda item. Is that right, the Secretary?
Yes, I confirm, Ambassador.
Okay, thank you very much. I would like to thank the ATT community, my co-chair, the Secretary for the contributions on the Treaty of Universalization. And I don't know, President, if you want to say some words before we move forward to the next agenda item.
Thank you, Ambassador Villegas, and thank you for the hard work you've put into this. And I would like to thank all the speakers, all the delegates who have stated their national positions as well as regional positions, and also civil society for the great work that they are doing with respect to universalization. Ambassador Villegas, Mr. Secretary, in moving forward to the next item, agenda item, I would like to kindly exit the floor to leave it to Ambassador Villegas to make his submission. And I thank you all, and I'll see you again tomorrow. Thank you, ladies and gentlemen.
Thank you very much. And as you know, we agreed to continue this, taking advantage of this meeting, but unfortunately, we have very few space for the interpreters to continue work. They have been very generous already. So basically, I wanted to share the possibility of moving forward in the paper that was presented by CSP7 President, circulated on November 2020 regarding the approach to resolving CSP6 draft decisions that were not approved during the cycle. As you know, we had a draft decision 17 welcoming the CSP6 presidency working paper. The decision was one of the decisions that was that the silence procedure that we adopted at that time was broken. So we decided to have bilateral consultation with those delegations that objected to the draft decision 17 during the silence procedure and make a presentation, which is what I'm doing today. Briefly, just to let you know that we were able to have a very good bilateral consultations with those two delegations, and we reached a consensus on a new amended language for that decision, draft decision 17. The first amendment was just an update, a chronological update, because it mentioned the diversion forum as something that would be created, and it was created by CSP6. And the second one is on number 7. We have a very good discussion regarding the role of the civil society in helping the cases of diversion detection process. We as Argentina believe that non-governmental civil society organizations play a crucial role in supporting the treaty implementation and provide valuable research. I think we had to keep the spirit of the treaty itself on the role of civil society. So we just introduced a small caveat regarding the participation of civil society to make clear that the cooperation with the non-state experts is needed when appropriate. As an example of how this cooperation, we mentioned Article 8 of the Terms of Reference of the Diversion Information Forum. The last amendment was introduced in the Recommendation 8, since we created diversion forums to share intelligence information, defense secrecy and customs secrecy. Certain countries will not feel comfortable to share this information in a context that does not provide sufficiently confidentiality. In this sense, taking into account the new subsidiary body that was created last year and the request of some delegations, we decided to delete the last part of the final sentence of this part. So these were the amendments. My delegation would like to present this new proposal, and I would like to give the floor for those that want to have an opinion on this. We already got, and thank you, Mexico, for advancing their support. And now I give the floor in these few minutes that we have left to the delegation of Perú. Perú tiene la palabra.
Estimado embajador, muchas gracias. Es un placer para la delegación peruana volverlo a ver, como siempre, comprometido con los trabajos del ATT. Este año copresidiendo el grupo de trabajo sobre la universalización del tratado y hoy presentándonos el texto revisado del documento de trabajo argentino. Esta intervención será breve debido a las limitaciones del tiempo. El Perú desea agradecer a la Argentina por haber continuado sus consultas desde agosto del año pasado. Compartimos la legítima aspiración argentina de que sus recomendaciones, derivadas del enfoque temático de la conferencia el año pasado, puedan ser adoptadas este año. Hemos revisado atentamente los ajustes efectuados, especialmente en la recomendación 7. Vemos el uso de algunas salvedades, caveats, que a nuestro juicio acotarían la participación de la sociedad civil en los esfuerzos de detección de casos de desvío de armas. Al respecto, permítanos dejar constancia de que esa no sería nuestra preferencia. El Perú considera relevante el rol de la sociedad civil, la academia y las organizaciones internacionales en apoyo a los estados para el control de las transferencias de armas convencionales y prevención del desvío. Dicho esto, sin embargo, comprendemos evidentemente que el documento que hoy nos presenta la Argentina no es nuevo y que el texto aspira a reflejar un balance de posiciones luego de consultas con diferentes partes interesadas. Es con ese espíritu entonces, y luego de dejar registro de nuestra posición, de que el Perú transmite su respaldo al REF 2 como está redactado en este momento. Muchas gracias, embajador Villegas.
Muchas gracias a la delegación de Perú y por la flexibilidad y por el apoyo. Le pregunto si, I would like to know if we have any other delegation on this, Dumisani.
Ambassador, we do not have any person who has requested to the floor from the chat room, so we don't have an additional speaker. Thank you.
Okay, thank you very much, and I really appreciate the effort of the interpreters. These are very difficult times, and they have been very, very generous. So I thank you for allowing me to present this. It's important to move forward to show that we are working well. We thank the interventions and the support, the flexibility of the delegations. Finally, I thank all delegations for the fruitful exchange of views in the intersessional work, and hoping to have the CSP7 approving decision 17 as amended. Since we learned from last year, I have to, if you allow me 1 minute, we made a very brave decision last year, which was to have a whole conference with silent procedure. And it was a brave decision, and we are learning from the experience. And so this year we will be able, with that experience, to have an even more fruitful CSP7 with discussions on this intersessional work has proven to be very important. So thank you very much for all the support and the flexibility. And with this, we reassume. Our president allowed me to close the meeting today. We will reassume tomorrow. Regarding the president's paper, sorry, it will be put forward as amended for approval for the next CSP7, regardless of additional comments that my delegations may have before that conference, of course. We will reassume tomorrow, Wednesday, 28th of April, with the meeting of the working group on effective treaty implementation. So thank you very much, and thank you, the interpreters and everybody, for their attention and support. With this, the meeting is adjourned.
Thank you, Mr. Ambassador Villegas, for your concluding remarks. And I wish to thank the facility, well, the interpreters from where we sit. I think they've been quite flexible enough. One last comment or announcement I wish to make is about a site event that will take place in about a minute's time from now. It is hosted by CIPRI. It is running under the title, Taking Stock of the ATT Implementation Assistance, Challenges and Lessons Learned. So we're inviting all delegates to participate in that site event. The arrangement for enlisting with the speakers list for tomorrow is as was announced yesterday. So if you can just send us an email in our info address, and we are closing at 1800 hours today, Geneva time. And finally, we request all those who be, well, all participants to join the meeting in a timely manner, not at 5 to 12, but a couple of minutes or some 20 minutes before that. It makes our life of facilitating entry into the meeting much easier. We thank you so much for your audience. And we would adjourn the meeting here. We'll meet you tomorrow at 12 o'clock Geneva time for the next session. Thank you so much. The meeting is adjourned.